Take your seats. We're running a few minutes behind, I think because of the transition between the floors. In any case, welcome back to the moot court. We foreshadowed this next moment, a discussion of a couple CUBE announcements, but I called upon Jared Brenner to tell us about the What If Wiki, which is one of the projects in the CUBE Innovators Competition. I'm going to hand it over to Paul Gangsey, the Executive Director of CUBE, to share our latest developments with you all.
So last night we had the first annual CUBE Innovators Competition upstairs in the room where you just had lunch. It was a great success. How many of you have ever watched Shark Tank? Well, this was Shark Tank at Brooklyn Law School, and it was a great success. We had 7 terrific proposals. They covered a range of different areas and interests. We had an excellent panel of judges. They made their difficult decisions, and I had wanted to introduce all of the 3 prize winners here this afternoon. Because they're entrepreneurs and doing about 8 different things at any given moment, a couple of them have had to go off to other commitments, but I'll describe the projects and then get a chance to introduce Jared again to you. So Austin Minogue won the 3rd prize for a project called Law Students Causing Change. And he hit on an experience that most of you have at least several times a year, if not more often than that. And that is you walk through a metal detector. You pull out your change. You go through, and then you take your change back and you put it in your pocket. He says, no, have a dozen different charities, one a month, and at different places such as courthouses where law students might have some access and connections. There will be a container, and that change, instead of going into your pocket, will go into the container and fund the charity of the month. So that was Law Students Causing Change. Tanya Barokova and Peter Potier, their project was called Share, Subsidized Housing Alternatives Through Renovation and Efficiency. And their goal is to combine within communities at a microcosmic level to start a prototype where you could combine owners, contractors, social service agencies, and families that need housing to identify particular units that can be rehabbed and made available. There are a lot of challenges to their idea, and I think the judges were impressed with the fact that this is one of the major issues in our city today, and that here are some people who are really committed to thinking seriously about another way to get at a niche of that problem. Jared Brenner described his own wiki to those of you who were upstairs at lunch. The whatif.wiki will create a new digital legal innovation commons for the exchange of ideas between entrepreneurs, law students, academics, practitioners, and other interested observers. And I'd like Jared to come up so we can all give him a round of applause.
Hey guys, thank you. I kind of gave away the store already upstairs, but for anyone who wasn't up there or was otherwise distracted, my basic idea is to create this wiki site, an encyclopedic collection of these various policy ideas we're always talking about where the law is not keeping up with the needs of innovative new ventures. I think there's a lot of potential to grow community on there and to link together a lot of people in different cities across the country and maybe even beyond this country who are thinking together and working towards solutions to these problems. That's the ultimate long-term goal of the project, is to be able to crowdsource new policy solutions, new legislative proposals, and discuss them on one platform. So I'm going to be starting to build the core team here at Brooklyn Law School in the summer, I'm hoping. Those of you here who are students, if you're not graduating or even if you are and you're interested in getting involved, I'd love to talk. Anyone else, practitioners, alumni, other attendees here, if you have any ideas to contribute to the project, I'd love to talk about that as well. And for anyone out there in the world, I'm at Jared Brenner on Twitter. You can reach me on there. Thanks so much.
So Brooklyn Law School is committed to working with Jared and each of the prize winners to help them make their projects a success. And next year, when we have the second annual Cube Innovators Competition, in addition to hearing some new proposals, we'll get a chance to hear reports of how it all worked out.
Thanks, Paul. I got to say, what I love about each of those winners is that each of them fits into one of the panels or demos or workshops we've had today, if you think about it. We got the one where you drop your coins at the courthouse. Maybe it's not crowdfunding, it's perhaps crowd unfunding, but there may be a seat at the table for them next year. Second one, the share one, they've been a perfect panelist in the technology for access to justice discussion. And Jared's, we already pointed out, would be a perfect platform for the creation of the Citizens Charter for Cyberspace. So as you develop your ideas, always think about your niche, the place you fit in. I think it's pretty clear. Sometimes you may be thinking you're doing something in a vacuum, but other people are thinking about similar ideas, maybe with different permutations, different tangents. But there are ways to connect it, and you should always be thinking about connecting those dots. Now, those are the students that just pitched their ideas, and they're going to spend this year building out those ventures. We've also got a few students, a bunch of 3Ls, who have already spent months, if not more than a year, developing some interesting ideas and platforms. And we want to spend a few minutes, just 15 minutes, 5 minutes apiece, for them to give a lightning demo on the ideas that they've been incubating. Some grew out of hackathons, some grew out of some class assignments, some grew out of just conversations that happen when we experience the adjacent possible. So our first group is a group of 3 students who built a project over a weekend. February 8th and 9th, we held our data privacy legal hackathon in London, in Brooklyn, in San Francisco. And I'm embarrassed to say, this is my favorite. They did not win. They did not win, but if they spent the past 2 months working on it, building it out, I think they should have won, but that's maybe my own personal biases. In any case, we had a hackathon back in January in which we were concerned about a concept called revenge porn. Raise your hand if you've heard of revenge porn. We're not quite the demographic, but it is becoming more and more prevalent, a huge problem. California and Maryland have instituted statutes combating revenge porn. They may not survive constitutional scrutiny. The students have picked up on some scholarship from a former Brooklyn law professor and have now decided they were going to build a platform to combat revenge porn using the Digital Millennium Copyright Act. So why don't you folks take it away?
Hi, so my name is David, this is Austin, and this is Sarah. I'm going to talk to you today about the problem of revenge porn. For those of you who may not be aware, revenge porn is when you send, your lover effectively an explicit sort of naked photo. And when that lover perhaps one day is not so much your lover anymore, and they upload it to a website. There's a number of websites who specialize in these types of photos, myex.com being one of sort of the most famous of these. Sometimes these photos are attached with the name of the victim, as well as their Facebook link and their address. This is a problem that, while skews toward women heavily, could affect anybody. In addition, this is not so much as only affecting someone's reputation. It can affect their economic well-being, as well as provide amazing, as one can imagine, emotional harm. This is also a huge, widespread issue. A 2012 Pew survey found that 1 in 4 adults had either received or sent one of these explicit photos, so was at victim of or was possibly could become a victim of revenge porn. The solution. As Professor Askin said, while a number of states have passed sort of laws criminalizing it, there are questions as to the validity with First Amendment issues. In addition, the rights of privacy, publicity, as well as intentional infliction of emotional distress are torts that are hard to do and hard to sort of prove. In addition, none of these remedies actually take down the photo. All they do is penalize the person who might have put up the photo. We have a new solution. Austin?
Thanks, David. So as students, as Professor Askin was saying, we held an event about this. We were concerned about the lack of law in this issue, specifically the effective law. So we built a solution leveraging the ubiquitous selfie. So as you know, maybe you don't know, selfies are pictures that the subject of the picture takes of themselves. It's a pretty straightforward concept. According to the Cyber Civil Rights Initiative, which is the leading authority on revenge porn, 80% of revenge porn victims take the photographs of themselves that are posted online. So we also know as lawyers that the photographer of a photo, unless otherwise contracted, owns the copyrights in those pictures. So the Digital Millennium Copyright Act, as Professor Askin said, enables copyright holders to request the removal of the infringing photos. And if the website would like to keep the liability shield afforded to them by the Act, they must comply with the request, otherwise face potential liability. So our solution, using copyright as an approach to help victims immediately. The DMCA notice system offers victims the potential for an immediate solution, which any kind of privacy law solution does not under current regimes. There are other added benefits to this. Most internet users don't know the fact that they own copyright in their selfies. So we corrected information asymmetry in that way. Similarly, they don't know that they can use the DMCA notice and takedown system for pictures that they've taken of themselves or of other people, and it also helps victims in that way. So we created a system, a working online system that's up right now in beta form, providing victims with the instant ability to issue these takedown notices and draft them. And Sarah's going to demo that for us.
Thanks, Austin. So our mission in developing this website, which we want to mention is still in its beta phase today. There's a few things that we need to work on, but it is fully functional. Our mission in developing our product was to provide revenge porn victims with a platform in which they could use this website to take down the photos that are spread all over the internet. Every hour, every day, every minute really that these photos are placed on the internet, the victim of revenge porn is experiencing reputational harm, potential career harm, and harm in their relationships as well. So our mission is to mitigate these effects. So the first step in sending a takedown notice here is to provide the website with biographical information. This information will only be used as contact throughout the DMCA takedown process should it be needed. Now the next step is arguably the most challenging for us and the most challenging for the victims of revenge porn. This is to identify the infringing website and the specific contact for that infringing website. Now this becomes difficult because owners of these websites don't want to be found, they don't want to be located, and they often change their specific contact information. So what we're hoping to do is develop an algorithm which will allow us to pull the specific data and contact information at the time the DMCA takedown notice is actually sent, and therefore we can ensure its accuracy. The next step is to upload the original photograph. And to preempt any privacy concerns here, this photograph will be deleted as soon as the DMCA takedown notice is actually sent. On this page, you'll also see that it asks the user to ensure that they took the photograph of themselves. As Austin spoke about, this is a selfie, and there is no debate as to whether or not the user or the victim in this case owns that copyright. Again, this is just to ensure that the correct photo is up and to make sure that the user is acting in good faith, which is a requirement throughout the DMCA takedown process. This just verifies that it's being sent. A copy of this will be sent to the user, the victim, and the allegedly infringing website. Our final product is an official DMCA takedown form that's populated with all of the information that the user specifically uploads into this. You'll see the website, and you'll see a description of the photo that the victim has uploaded. We just want to send a special thank you to Mark Olblad, who without his help with coding this website during the legal hackathon, this project wouldn't have been possible, and to Professor Askin for all of his support throughout this process, and we really hope that this ends up helping the revenge porn victims. Thank you.
Thanks. I got one question for you all. Is Elisa from Glimpse still in the audience? Elisa, are you still here? No, I think she may have left. Do you if I was uploading to your site, I'd be potentially equally scared to upload my photo to your site. I don't know who you folks are. Do you think there's a secure Snapchat or Glimpse-like capability that could be built in on the uploader side so that their photo doesn't rest with you in perpetuity.
Yeah, there's already a mechanism involved that deletes the photo, but obviously we want to ensure that we don't keep anything that would allow any victim to be victimized again. So obviously it's a key part of the website, and obviously we want to work with anyone to improve upon that and also to improve upon any other aspects.
Yeah, we actually built, just wanted to say one thing, we actually built privacy by design measures into the product. So the images after they're uploaded are destroyed by the system and they're not cached. So the only place that the images are actually being stored are in the outbox. And if the outbox is set to delete upon send, then it's strictly privacy by design. There's no chance of the images that they upload ever being leaked.
I think this is a great example of soon-to-be attorneys using technology, the internet, innovative tools to do that which the Constitution and the law possibly do not allow.
Thank you.
Thanks.
On that note.
Great. Our next demo is more than a year in the making, a year and a half in the making. So Gabe was a student in the Blip Clinic last year and spearheaded a concept. This was, who's familiar with the America Invents Act? Most of you. Actually, Gabe, you're going to talk a little bit about the history of the American Invents Act and why, and the launch and all that. I'm leaving it to you.
Hello, my name is Gabriel Goldenberg. I'm a member of the Blip team that created FirstDisclose.org. FirstDisclose.org is a website to allow inventors to publicly disclose their invention so that everyone has access to it and sees it. The Blip team I was a part of created FirstDisclose.org in anticipation of the change in the IP framework that the America Invents Act would put into effect on March 16th, 2013. And what the American Invents Act did is change the patent system from a first to invent system to a first to file system. What that means is the first person to hand in their application to the USPTO would get credit for the invention instead of the person that could prove that they were the first one to come up with that invention. So with the American Invents Act, there were inventors could create pre-filing disclosures, which would start the 1-year grace period, which would allow them to complete their patent application process. Another use is defensive disclosures, which would allow the inventor to publicly identify their invention so that another company can't then go and patent that invention and then prevent other people from using it or require licensing fees. What First to Disclose allows people to do is upload these inventions for free. Patent examiners and other people could search those disclosures for free. It's easy to use, just like most of the popular websites out there. It's built on the WordPress platform, which is familiar to a lot of people. The other benefit of it is that it creates a sort of standard for these types of disclosures. A disclosure, once it's uploaded, is date stamped so that there's no argument about when the disclosure was made, and it's also centralized so that people know to come to First to Disclose to search for these disclosures. This is an alternative to someone just posting it on their website or other websites that allow them to post any sort of internet content, because depending on what search engine algorithms are doing that week, you may not be able to find that particular disclosure or invention, or someone might make changes to that website and your disclosure will be lost in history. So I'll just briefly show you First to Disclose, and I'll let you know about our progress. So far, First to Disclose has submitted a comment to the USPTO recommending that they consider using this as a tool for patent examiners to examine prior art. We're also constantly soliciting feedback from the IP community to make this an even more useful tool. I'm not going to go through all this. It's an active website. You're welcome to do this at home. You would make a disclosure by going to Submit Disclosure, and you'd be able to search disclosures by going to Search Disclosures. So this project is only useful if the legal community and the inventor community starts using it. This was a project that was bootstrapped by a couple of BLIP members and by Professor Askin. So we're looking to the legal community, the inventor community, to spread the word and encourage inventors to use this if this is the right option for them. Thank you.
To me, I think it's going to be most advantageous for those of you from the Information Wants to Be Free camp, the open source free culture community. A great place to share your ideas and not allow anyone else to actually claim the idea. That's probably its most efficacious use. Our last student demo is by way of entree into our next panel. So Boyan and Alana, come on up. They've been working on something called the G Corp. We've been working on it for a while now, and so this has been in a sort of perpetual beta state for a while. We hope that at some point it will see the light of day and be a useful tool for socially responsible, internet-oriented enterprises.
Presentation. I don't have a link to yours. Let's see.
While they're setting that up, I'd like the next panelists to view this with a critical eye. If time permits, we could dissect this a little bit. I know some of you have thoughts, more mature, seasoned thoughts on what the future of the social entrepreneur looks like. So we'd like to get your take on how this might fit into the evolution of social enterprise. Anyone have any thoughts or comments they want to share? Yes. Eric, you want to yell or you want me to bring? I'll bring it back.
I'll just yell. So I was thinking about disclose.
Can you see them here?
And I was thinking, wouldn't it be neat and maybe even a little more useful if, when you submit your disclosure to First to Disclose, there's a button you could click that would also file that disclosure as a provisional patent application with the PTO, so that if you weren't sure if you wanted it to be public or not public, you didn't have to decide then. You could put that off for a year.
Gabe, you want to field that question? It's a great question. Eric, we should have used you as an advisor on the project.
I have a patent on that.
Don't we have a retainer with you? Aren't you an official mentor to the Blip Clinic? All right.
So I think that is a great idea, and that is the type of feedback that we're continuing to solicit. We're working with some large companies and getting feedback from them now that are considering using the system. And we're trying to implement things like that. So I encourage all of you to contact us and work with us to make this the system that it seems like the community needs.
And by the way, before I hand it over, I do want to point out that if it weren't for me, that guy who just spoke in the back would probably be about a billionaire at this point. He was one of our first Blip students, always had what I thought was a crazy harebrained idea. 3 years later, every single one of his ideas, someone had built and sold. Whatever it was. He left his firm at King & Spalding and is now embarking on his own law-related entrepreneurial venture. Again, against my better judgment. No, but when you make $1 billion, don't forget us. Anyway, I'm going to hand it off to Alana and Boyan.
Sorry about the delay. I'm Alana, and this is Boyan. We're going to talk to you today about G Corp, which is a set of third-party certifying standards that we've been developing along with another organization called Goodnick for socially responsible internet-based startups. So Boyan and I are in the Bleak Clinic, which, as you may know, provides legal services to startups. We are on a team that Professor Askin has coined the Leonardos from Ninja Mutant Turtles. And we're the do-gooders. That's sort of the theme of our team. We're the ones who help the nonprofits, the startups who want to do good. And for a lot of the startups that we've been working with, they want to find a way to be able to show the community that they're not only trying to make a profit, but that they also want to serve the community. And this is where G Corp comes in. And I know a lot of you might be thinking, well, doesn't B-Lab do that? Doesn't B-Lab provide these third-party standards for socially responsible ventures? And that's true, and B-Lab is great, but it doesn't necessarily fit the model for small internet-based startups for a couple of reasons. First of all, for these small organizations that maybe have one or two co-founders, it might be a little unaffordable for these individuals. And also, there are a lot of new and interesting ethical dilemmas that face these organizations that they want to be able to voice that they're accounting for. So things like data privacy, transparency, and open sourcing are things that these organizations want to say, we're looking into it and we're practicing ethical practices when running our startup. Now, a lot of what G Corp will be accounting for are the basic social standards, similar to B-Lab, things like philanthropy, anti-corruption and whistleblowing, environmental impact, and fair compensation and wages. What's particular about G Corp as well is that the bylaws that we've developed for them are ones that meet the size of the businesses that are at hand. So, for example, for philanthropy, there is a requirement that we ask for companies to develop in their bylaws to contribute some philanthropic efforts, whether it's their time or whether it's some of their profits, but it's based on a percentage of what their business earns, which makes it affordable and reasonable for smaller businesses.
As Alana mentioned, a number of our standards are geared towards the technological and the consumer-facing treatment that companies, the way that companies treat their consumers. So those standards include intellectual property. So we want companies to open source and to only use their patents and their intellectual property defensively. We want transparency, so we would like companies to be as open with their consumers about their business processes and their data usage as possible. We want them to honor consumer rights. We want them to treat consumers fairly and to make sure that they protect their rights of free speech and association. We want them to have strong data privacy and security protections. And finally, as much as possible, commercially possible, we would like them to open source their software. So the way that companies will participate in our standard would be one of two ways. So they would either self-certify to adhering to one or more of the principles that the standard sets out that wouldn't qualify them for a full certification as a G Corp. What would qualify them would undergoing an outside audit. And of course, since we're gearing this towards young companies that don't have a lot of money, the model for this would be ideally one with very small fees for outside auditors and probably one managed by Goodnick, which is the nonprofit that we've been partnering with that would be running the G Corp model ultimately.
Thank you.
That's terrific. Thanks a lot, folks. Now, I assume you're aware that we actually do have a representative from B Labs in the room and who will be sitting on the next panel. I suspect she may have some good insights into what you've done and what B Labs is doing and how they may work with startups. In any case, I'm going to hand it over to Dana and the social entrepreneurship panel. We're fortunate at Brooklyn Law School to have not one but two of the leading. Why don't you all take the stage? Two of the leading academics, legal thought leaders on the evolution of social enterprises and statutory and other structures that could and should govern them going forward. So I think we've got a panel of strong opinions, all subject matter experts to the extent anyone can be in such a novel and new area. Dana, I'm going to hand it over to you and take it away.
Okay. Thank you all for coming. And it's very exciting, very dynamic, not like your typical academic conference in any way, which is, I'm sure, exactly what Professor Askin was trying to do. So you've disrupted yet another tradition in a good way. As Jonathan said, I do just about all of my academic work on social enterprise and financing for social enterprises. And I'm joined on the panel from people who actually do and don't just teach. So we have folks practicing in this space, obviously Holly Ensign-Barstow from B-Lab, and we've got Alan Bromberger and Neil Jacobs, who are both practicing in this really vibrant area. So Holly, are you going to start out?
I can if you would like me to. I do have a presentation.
All right, maybe we should get that started. Can you find Holly's slides?
Do you want me to stay here or go there?
Whatever's your preferences. Great.
I wouldn't mind clicking my own slides.
Okay.
Okay. So, my name is Holly Ensign-Barstow. I work for B-Lab, and it's been mentioned, I would assume, multiple times today. It's a national nonprofit whose mission is to use the power of business to solve social and environmental problems. We have 3 initiatives. I'm going to go over them very, very briefly because I don't have very much time. Our first is to certify companies according to their environmental and social performance. That's the certification that was mentioned before. There are about 1,000 certified B Corps across the country today. And from there, we went to work with investors, impact investors, and providing them the analytics and ratings tools that they need to really analyze these companies' missions and to make wise and quick investment decisions. Through our work with these 2 industries, with these 2 groups of people, we determined that this is an industry, a group, part of the market that really has tremendous potential. There's about 60 million conscious consumers out there today. Those are consumers that are, using their own beliefs to make market choices. There's about $2.7 trillion of social impact investing money that's available for these companies in the market today, and about 200,000 self-identified sustainable businesses. Now, that's a huge potential market, but we found that it's actually being constrained by current corporate law. So to solve this problem, we worked with Drinker, Biddle, and Reef to create the benefit corporation model. And I'm going to let the lawyers talk about the details of that model, but just to kind of give you a very, very brief synopsis, is it's a voluntary corporate form that allows directors to hold their companies accountable to higher standards of purpose, accountability, and transparency. As of right now, there are about 550 benefit corporations around the country. This is an estimate because not all secretaries of state actually track the number of benefit corporations. As you can see, there are some incredibly well-known companies that have become benefit corporations. Patagonia, the clothing company in California. Plum Organics, which is a baby food company, also based in California. Grayson Bakery, which is actually up in Yonkers. They make the brownies for Ben & Jerry's ice cream. And Method Products, anybody who's been to a Target who knows what Method is. And there are also some more traditional companies. Solberg Manufacturing, based in Illinois, is a manufacturing company that produces vacuum filters. And they chose to become a benefit corporation because this is the ultimate expression of their business philosophy. This is the way that they're going to be able to bring on outside investors while protecting their mission. The legislation so far, this map is slightly out of date. We actually have passed in 23 states right now. 3 states since the beginning of 2014. And in the last week, 2 states have actually been signed by the governor. West Virginia and Utah were just signed yesterday and the day before. And we're waiting on the signature in Nebraska. We're moving forward in about 12 states this legislative session. And I'm hoping to hear really good news in the next couple of weeks from New Hampshire and Florida. So just as an FYI, if you guys want to learn more, this is kind of the clearinghouse of information for all things Benefit Corp. It's www.benefitcorp.net. There's tons of information there, how to become a benefit corporation, what it means for a business, what are your liabilities, information for attorneys, and things like that. So short and sweet, there's my contact information.
Great. Well, why don't we hear from the other panelists, and then we can, I'm sure, get a dialogue going. So, Alan, take it away.
Sure. Thank you. I'm Alan Bromberger, and I'm a practicing lawyer in New York City. My practice focuses almost exclusively on social entrepreneurs and businesses that are sort of non-traditional or looking to combine both financial and social goals at the same time. And if we can get that slide up there, we're looking for it. It's an illustration of what.
Can you give me your membership unit? Sorry.
Yeah, it doesn't. Maybe. Anyway, really the important point to make here is the fact that when you look at sort of, when I went to law school, there was no, there was sort of, if you wanted to go into business, you would be a corporation or you would be a partnership, and the corporation had limited liability and a lot of protections, and so it was favored by certain types of businesses. And partnerships had a tremendous amount of flexibility, but no protection from liability, and so people were forced to make a choice between which way they were going to do until the LLC was invented, which is essentially a partnership with limited liability and other protections that traditionally were enjoyed by corporations. The problem they have right now is that the law is divided into charity and business. And for the last 40 years or so, the whole regulatory system has been based on keeping these two things separate, and based on what is, in a sense, a cultural bias that says charity is about doing good and it's not about making money, it's about helping people. And if people who run charities are making money or anybody's benefiting from it, it's considered evil. And business, on the other hand, is about making money, and under traditional jurisprudence, businesses don't owe any don't have any social responsibility. Their responsibility is entirely to their shareholders. That's a little bit of an overstatement, and there have been various things over the years to try to mitigate some of this. But fundamentally, we still live in a world that is dichotomous. And what is interesting about social enterprise is that instead of a divergence of those two things, you have a convergence. So we now have an entire generation of people who are trying to do businesses that do good and do well at the same time. And unfortunately, the legal system is just out of whack with that. And so a large part of my practice and a lot of what we're all talking about, and I think a lot of what's going on here today, is how do you find ways to get those two objectives to coexist peacefully? And not just talking about corporate philanthropy or some of the things like that, but how do you actually run a company in a way that's oriented towards not just shareholders, like a profitable company, but where you're also thinking about your customers, you're thinking about the community, you're thinking about your employees, and you want to run your company in a way which is responsive to that. So what you see on the chart up there is that we sort of start from the point of these charities and these for-profits, and there are a lot of things that charities are doing these days to become more business-like and become more oriented, and some of them are listed up there. And there are a lot of things that for-profit companies are doing to be more philanthropic and more civic-minded. But the point of the chart is that those arrows don't meet. There is no continuum. That as companies become sort of more and more civic-minded, the analogy that I use is that the ice starts to thin, and at a certain point you hear this cracking noise, and shareholders get nervous, and boards get nervous, and their lawyers get nervous, and everybody gets nervous. So you can go some way down the path, but you can't go as far down the path as social entrepreneurs would like to go. And the same thing for charities. A lot of charities have very significant commercial activities and operate only like businesses, not just small ones, but Children's TV Workshop and National Geographic and hospitals and universities that have very significant commercial activities. And yet fundamentally their board is got to be oriented towards mission, and the question is sort of when does the tail begin to wag the dog? At what point do you say, well, you're really no longer a charity, now you're a commercial entity, you're really operating like a business? And the law in this area is really quite unclear. And so what a lot of practitioners in this area are focusing on now are these sort of so-called hybrids, where you use a kind of a combination of both. And I do a lot of this kind of work. So we're sort of left with three questions here, which is, as a charity, how far can you go before you run afoul? As a business, how far can you go before you run afoul? And then if you want to live in that middle space and have a hybrid and have a nonprofit and a for-profit coexisting, and I've heard a number of people already today talk about how they have a business that's cooperating with a nonprofit or vice versa. How do you actually get those relationships to work, and how do you document them and make them work? So there are a couple of things. One is there is the emergence of these new legal forms. From my point of view, the Benefit Corp is by far the strongest and best of them. It's certainly not the only one, but it's being very widely adopted. It was very well designed and thought through, and I think that's, at least until something else comes along, that's probably what most people are looking at, because the Benefit Corp allows you to embed a social purpose into your organizational documents. And if you do that, the board of directors actually has an affirmative duty to pursue the social mission, which is roughly equal to its duty to deliver profits to shareholders. Having said that, there's not a single court case anywhere. There's nothing. So anybody who says they know the answer to any question like that is making it up. Nobody really knows, but we're beginning to get there. And as more and more states adopt this, and there's beginning to be an academic literature around it, some of these questions, I think, are going to begin to be answered, and some norms are going to begin to emerge. But by the same token, if I have a nonprofit client and they want to create a for-profit subsidiary to commercialize some product that they have, for example, universities are a really good example of this, because the model used to be that universities would do research and they would develop some idea, some invention that had commercial viability, and they would license it to private companies who would take it out into the marketplace and make a bunch of money. And the universities discovered that they were leaving a lot of money on the table, because when they were just licensing the invention, it was unproven, they didn't have a good business model, and so they were essentially ending up selling it relatively cheap. And what most universities are now doing is they have business development units, and they actually start these companies, and they bring them to market, and once they're able to prove the economic viability and the successful business model, then they can sell them to private industry, and they make a lot more money. So here again, you have nonprofits, universities, the classic 501c3, that is now engaged deliberately in commercial enterprise, and how far can they go? Benefit corporations, for example, are a really good vehicle for those kinds of things, because you can actually bake a social mission which is consistent with the mission of the charity and it gives some reassurance that although that's a business, it's also going to adhere to some extent to the mission of the charity. One of the big disadvantages of benefit corporations is that there are different flavors in different states. Some of them require benefit directors, some don't. Some of them require that you measure what you're doing against a third-party standard. Some don't. Delaware just passed it, and they don't have the third-party standard in it. So it's very different, and people are actually rushing to Delaware to incorporate benefit corporations right now, partly because everybody loves Delaware, but partly because the compliance in Delaware is much less than it is in other states. And this sort of leaves open the question, well, what happens when the third-party standard, if you even have one, is developed by the American Petroleum Institute or something like that? So the fact that it's a benefit corp, which is in some senses intended to signal to the market that it's a different kind of company operating a different way, may or may not hold up depending upon how this stuff all plays out. So just a very, very brief thing about choice of form. I don't know how I'm doing here on time, but I'll try and do this very quickly because I know we have Neil particularly. I want to see if he can talk a little bit about how you actually finance these companies and run them and capitalize them, because it's a very big, it's a very important thing. Is that generally speaking, what I tell my clients is you need to look at your capital and where it's coming from. Is it donated capital, for which there's no return invested? You're being financed by a foundation or by a philanthropist because they believe in the social value of what you're doing, and they're not necessarily caring about a financial return? Or is it invested income, where you have profit-oriented investors who may love the social mission, but they're also wanting to make sure that they're going to get their money back, and that hopefully they can get a profit on top of that? If it's donated capital, that would argue in favor of using a nonprofit form as the vehicle for your venture. If it's invested capital, that would argue in favor of using a for-profit model for your venture. And the second thing is where your revenue is going to come from. If it's earned revenue from the sale of products or services in the marketplace, that's going to suggest a for-profit model is going to be the right model for you. If it's going to be donated revenue, and there are lots and lots of these models where, I mean, you know, people are raising millions of dollars on Kickstarter, and nobody's getting a share of stock from any of that. The crowdfunding and the crowd raising has opened up entire new ways for companies to capitalize themselves, and they're not selling a single share of stock in return for all that capital. That may or may not suggest that a nonprofit is a better way to go, although plenty of for-profit companies are literally starting up using donated capital. And so it's a complicated decision, and for those that say, I'm not one or the other, I need both, and we see that a lot, that's where this middle space, which is the hybrid, is all about. The last thing I'll say about hybrids is that the biggest single issue right now in the law around hybrids has to do with control. The IRS has basically taken the position that where you have a small group of people who control both the for-profit and the nonprofit, it's dead. It's not going to happen. You're not going to get tax-exempt status, because the presumption is that the small group of people who control are going to use that charity to benefit the business, which is not allowed. You can go the other way, but they just presume that human nature is such that if they control both, they're going to use that charity to make money for themselves, and it doesn't matter how much you argue. So one of the things that you have to think about, and it adds a lot of complication, is having independent boards, having independent entities, arm's length transactions that are a lot of formalities to deal with. You have conflicts of interest to deal with. You have private benefit. There's a whole long list, and if I had 2 hours, I could do the whole presentation. But I just want to flag for you the fact that although the concept is simple, the execution actually can be pretty complicated. So I'll stop there.
Great, thank you. And now Neil Jacobs.
Thank you, Dana. I'm Neil Jacobs. I'm the founder of N.I. Jacobs & Associates here in New York, and I'm also a 1983 graduate of Brooklyn Law School. So for those of you who are still students, I do remember the days when I was sitting on that side of the aisle rather than this side. My practice consists principally of corporate and transactional work relating to startups, technology companies, media companies, social ventures, and I spend a significant amount of my time on pro bono matters, principally related to bottom-of-the-pyramid, market-oriented solutions in the developing world. So you put all that stuff together, and you can see why I was thrilled that Jonathan asked me to be part of this panel today. First of all, I want to basically second everything that Alan just said. I think everything that he said is absolutely correct, not simply because he spends most of his time doing this, because I think what he has expressed to you is actually what I found and what other people I know who are active in the space have also found. The problem in a nutshell is that in terms of these new entities, there isn't really enough law out there in the sense of judicial decisions, state regulations, and so on, in order for us to be able to come to some sort of unified theory with respect to what a benefit corporation is. But I'd actually like to spend most of my time, if I may, talking about hybrids and about the corporate aspect of benefit corporations. And the reason for that is this. When we talk about hybrid structures. They usually involve a 501c3 nonprofit organization and a for-profit subsidiary, whether it's an ordinary corporation, an LLC, or some other type of business entity. And it's the ordinary business entity that actually goes out and raises funds, so to speak, not for the charitable mission, but rather for the corporate mission. And the point that I want to emphasize is that those entities are, in many respects, ordinary business entities. Yes, a benefit corporation is subject to a variety of self-imposed and extremely socially positive strictures, but it is still essentially, it's formed, for example, in New York under the New York Business Corporation law. If it's a limited liability company, it would be formed under, or a limited liability company that's a subsidiary of a non-for-profit corporation, it's formed under New York's Limited Liability Corporation statute. So when you approach the issues of capitalization and funding of these entities, you have to think basically in ordinary business corporation and LLC terms. And this is something that's very important. Now, for those of you who are out there who expect to either practice in this area or expect to actually launch a venture in this area, I would have a few takeaways. And takeaway number one is the same takeaway that I give to all of my clients who are launching in the for-profit space, and that is save your equity. Everyone thinks that if they get into business for themselves on an entrepreneurial basis and they start out with 100% ownership of a company, that 100% ownership of a company is something that they can effectively use in lieu of cash compensation. Well, no. You can use it in lieu of cash compensation, but you should not. You should be constantly keeping your eyes on the prize, which is the ultimate exit event, or in the case of a hybrid organization, creation of additional value for the nonprofit that sits at the top. So don't just give it away. Ask yourself each time that someone seeks equity from you whether or not they are really adding value to the pie. If the value that they're adding to the pie really makes the pie bigger, then they can take their equity and you'll have a smaller piece of a bigger pie. But if what they're doing is not really adding value and you're simply putting people on for purposes of window dressing, you're hurting nothing but yourself. And when you hurt nothing but yourself in the for-profit side, be it a benefit corporation, a wholly owned subsidiary in a hybrid situation, you're only going to end up hurting the social mission. So why are you bothering to do this? Keep in mind that you have to act in terms of governing that entity as if, in many respects, it were an ordinary corporate entity. Another point I would like to make is to place what we're talking about here into a different type of a context. We are talking specifically today about benefit corporations, about B-Lab certification, which in certain places is required for benefit corporation status, but in other situations is not. Sometimes people will certify as benefit corporations for B-Labs, but not establish themselves as benefit corporations under state law for a variety of reasons, and these hybrid type enterprises that we are increasingly seeing. This is a fairly narrow slice, albeit growing slice, of the business world in general. I think that Holly's point at first, where she began to show numbers with respect to, or spoke about numbers with respect to socially oriented businesses and people who deploy their assets on a socially oriented basis, is significant and growing. But it's also growing into the for-profit sector. And what I mean by that is this, that if we talk about social entrepreneurship generally, we need to focus certainly upon these specific structures since they're the most common. But we also have to take a look at what's coming next. And what's coming next is the overall social and economic effect that these type of structures are beginning to have on the rest of the business community. There is significant additional buy-in by corporations of all sizes, shapes, and colors for social responsibility generally. Historically, corporate social responsibility, or CSR, was nonsense. It was a way of whitewashing, or as we call it these days, greenwashing, most companies' real lack of engagement in the social sphere. That isn't the case anymore. I'm speaking anecdotally, and Dana, you may have some data to back me up, but I'm increasingly finding, and it's one of the reasons why I'm heartened in a sense by what the folks at G-Labs are doing, that certainly in the smaller entrepreneurial venture space, even those entities that are specifically forming as for-profit entities do so with a social mission in mind. They do so with a significant degree of ecological consciousness. They do so with a significant degree of consciousness for fair trade and anti-child slavery issues. They do so with with an awareness of a variety of other social issues that may end up impacting the way in which they do business. Now, even if they do not end up certifying as B corporations with B Labs or any other alternative certifier, or whether or not they become benefit corporations per se, the effect of this entire movement should not be understated. It is, in my view, it is the direction in which business generally is headed. I think part of the reason for that is being driven by technology and transparency overall. I think companies recognize that if they are polluting in their own backyard, they're going to be found out. And they're not going to be able to greenwash themselves as saying, look at the 3 playgrounds that we built, when in reality they destroyed 3 communities nearby. The impact of the entire social business movement, I think, really needs to be kept in mind. Another point that was alluded to a little bit earlier, and I think Alan touched on it a little bit, is crowdfunding. And I'd like to talk about crowdfunding insofar as social ventures are concerned. At present, the only crowdfunding websites that are out there are non-equity crowdfunding websites. Kickstarter, Indiegogo, you can fund a particular project. You can pre-purchase, for example, a particular product that you think is going to be great. You'll provide the manufacturer essentially with the money to go ahead and manufacture the good, and you'll get the first line. Equity crowdfunding is still up in the air. The Securities and Exchange Commission issued proposed regulations about 30 days ago, I think. Has not become effective yet as to whether equity crowdfunding is going to be, or not whether it will be, but rather how it will actually function. My view is that equity crowdfunding is likely to be a disaster. It's not likely to have a tremendous impact either on the companies that are seeking equity crowdfunding or on the companies that are acting as the portals. I think it's unfortunately, and I'm very much in favor of entrepreneurship, as I think you can tell. Someone said that the Jobs Act, under which equity crowdfunding was permitted, should have been called the Jumpstart Our Bucket Shops Act. And I think that's what's going to happen. I think there's going to be significant fraudulent activity in the equity crowdfunding space. Having said that, that is not to say that crowdfunding would not make sense for a particular hybrid project. And I'd like to close, if I may, with a story or an illustration, because for many of you, the idea of what a hybrid is may not really be realistic or tangible. And I was talking to Alan beforehand about this. I had a situation recently in which a client came to me. They were a 501c3. They had started out as a 501c3 nonprofit organization for purposes. It was founded by a former Peace Corps volunteer who had done her Peace Corps time in West Africa. And she noticed that women in a particular West African country were the great collectors of shea seeds, nuts, whatever they are, whatever shea butter is made from, and they would make this butter. But of course, they couldn't really sell it because they were isolated. There was no infrastructure. There was no business infrastructure. She decided to create co-ops and co-ops of co-ops in order to enable micro-entrepreneurs on the ground to be able to develop their capacity and to have a way of actually distributing their product. And lo and behold, she did that, and she actually purchased some of their product and started selling these shea butter products. Skin creams, soaps, lotions, and creams, and so on. She had very, very small activities. We're probably talking under $25,000 for several years, until such time as someone from the cosmetics industry happened upon her products at a trade show and said, "This stuff is unbelievably good. We need to put real money into this." And at that point, she approached me for creating a for-profit subsidiary and for creating the relationship between the nonprofit and the for-profit. It's exactly the sorts of issues that Alan had, in order to be able to take advantage of the sales of this effectively brand new high-end cosmetic product, which also at the same time functioned as the ability to service the community for which the 501c3 had been aimed, which is the women who are creating these co-ops in Mali. This story has a happy ending. About 2 months ago, there was a funding took place of the for-profit entity by an African Growth Fund that's led by Dick Parsons, formerly of Citibank and Time Warner AOL, and Ronald Lauder of Estee Lauder and Company. They put $750,000 into it. So again, this is what makes me optimistic about this entire area, not just in itself as a niche, but rather as a portent of things to come and as a way of shifting the paradigm of how business should be approached. Thank you.
Thank you. Well, all of you gave us a lot to think about, and as someone who is, always sitting in my ivory tower thinking about these things, I have a whole bunch of questions. I'm just going to start with one for each of you to get the ball rolling, and maybe there'll be a little bit more dialogue if we have enough time. I just want to make one clarification. I think in your comments, Neil, you mentioned the relationship between B Corp status and benefit corporation legislation, and not everyone maybe lives and breathes this quite so much as we do, and so I just want to make sure that folks understand. So, and Holly, please correct me if I'm wrong. So B Corp is a mark that you can license from B Lab, and any kind of organization, in fact, it doesn't have to be a corporation, it can be a LLC or something else, and become B certified by going through their process and obtaining a certain score that shows on their terms, by their metrics, that you are the kind of company that deserves the mark. Benefit corporation status is a state-defined status available in, I guess now, 23 states, where there's enabling legislation in that jurisdiction to allow corporations to form or reorganize as a benefit corporation, and in order to do so, they have to follow the requirements of the statute. Most, although importantly not Delaware's benefit corp statute, do require someone who is forming a benefit corporation to apply a third-party standard to judge that they are meeting a purpose beyond purely profit. That third-party standard could be the B Corporation status and obtaining the B mark from B Lab, but it could also be another third-party standard. And the applicant corporation applies that standard to themselves. They don't have to go to B Lab or any other certifier and be certified by the third party. They only need to use the third party's metric to judge themselves. Is that correct?
That's correct, and that's true for all states. You use the third-party standard as a rubric to create your own benefit reports. Delaware is the only state that does not require the use of the third-party standard.
So very, very important to keep those ideas that sound similar, and obviously B Lab has been involved in both efforts, but to keep them separate because they do quite different things. So Holly, my follow-up question for you, I'm a really big fan of the B Mark product and that kind of private certification. I think that it can do good work, including the consciousness-raising work that Neil was talking about. My sense of the benefit corporation so far is that it's a fantastic legislative product, that legislators love it, and why wouldn't they, right? You go to the legislature, you say, you should enable businesses in the free market to solve social problems. It's something for the right, it's something for the left, kind of who could complain? Of course it's passing like wildfire across jurisdictions, but it doesn't seem to me like it's been so far penetrating as a really good product for organizations because they don't seem to be adopting it at a very fast clip. I know you've got some, big names, a few big names, but, even with your count, you're under 1,000 entities in a couple of years with 20 some odd states. So do you think there's going to be, at some point, this huge rush to the form, or is it more about consciousness raising than the form being really useful for entities?
I think that a lot of it has to do with consciousness raising. I mean, there are two of us that work on benefit corporations at B-Lab, and there's only so much that we can do. So we go to as many of these types of events as possible. And after the legislation passes, we do a workshop if we're lucky in that state. And then we have an effective day event for the companies that incorporate. But, I mean, that's about as much as we can actually do for that state. So I think that a lot of it is consciousness raising and getting the word out there. We're only as good as our contacts. And some states that we don't have that great contacts in. So I think it's just, a lot of it has to do with educating the public, educating lawyers, educating investors, educating businesses.
Alan, maybe you can come into this conversation now. I wonder if it's possible that the product, although it's identified the problem of this concern about having a dual mission and trying to embed it, if it really is solving the problem, just by adopting the form. Myself, I've been critical of the lack of enforcement included in the statute, either public enforcement or private enforcement, other than by shareholders. But Alan, it sounds like many of your clients are adopting a different model by using multiple organizations. Is part of that to create a kind of enforcement mechanism? If you set up a benefit corporation with a nonprofit, do you have more ability to control?
Well, if the benefit corporation is controlled by a 501c3, which is by definition operating for charitable and educational purposes, it is, for all intents and purposes, an asset of that C3, and therefore can only be used in ways that are consistent with tax exemption. But I think there are 2 points that need to be made here. One is that I think right now it's absolutely true that there's virtually no authority on benefit corporations, and so as lawyers we look, I mean, I do deals and I'm talking to people on the other side of the deals and I say benefit corp and they say what is that, and they look at the statute and it doesn't make sense to them and they're not comfortable with it, so they say to their clients, we don't know what this is, and uncertainty creates risk, and risk screws up the pricing of your deal, and so people tend to stay from it. But I think that's also a function of the fact that we are still in the infancy here. And I like to draw the analogy to the LLC, because the LLC was created in 1977 in Wyoming. It's a great story about how LLCs came to be. There were basically a bunch of legislatures in Wyoming that had a particular problem to solve, and they were trying to do business with a company in Texas, and Texas said, well, we want to come up to exploit some mineral rights, but we can't form a corporation in the state of Wyoming, and we're not willing to do a partnership because of the liability risk. And they literally sat around at about 4 o'clock in the morning after drinking a couple of bottles of Jack Daniels. They said, well, wait a minute, why don't we just create a partnership that has limited liability? And they just invented it and solved that particular problem. For 10 years, virtually no other state adopted an LLC statute until 1987, when the IRS gave a ruling as to whether this entity would be treated as a corporation or a partnership for tax purposes. Within a couple of years, I mean, LLCs now are everywhere because there was uncertainty. And until that uncertainty was resolved, people were too scared to move forward. And we don't have cases, and we're still very early, and the norms don't exist, but more and more people are learning about it. There are more and more examples of companies that are doing it and doing it successfully. There are going to be more and more stories of companies that are abusing it and using it as a, for a sort of marketing device. Here's a gimmick. Oh, we're a benefit corp, so we're a good corp, and they're going to go out there, and really they're not. And again, you have to keep in mind what Dana said is extremely important, that the B Corp, which is a trademark, you have to go through an interview process and you have to be certified, and you are then audited by B Lab based on that. My law firm is a B Corp, although we're not a corporation. And it was a real challenge for us to get certified because it's a pretty rigorous process. It was interesting because it forced us to look at a lot of our internal operations. So any of you that haven't done it, I actually suggest you go to the B Lab site and look at what the interview process is, and take that interview, because there's no obligation, and just see how you do. It'll really force you to think about internally how you're operating and challenge your assumptions. But the benefit corporation doesn't have anything like that. There is no real enforcement. But wait until we have the first shareholder action where some company says, well, yeah, our social purpose is to do X, Y, and Z, and they're doing, in most states, the company has to do a public report as to what it's doing to further its mission. In Delaware, the report only goes to the shareholders. But at some point, some shareholder is going to say, hey, wait a minute, you're not doing affordable housing, or you're not improving health care, or you're not developing economic opportunity in a disadvantaged area. And I invested in this company with the knowledge and the understanding and the promise that you were going to be doing that. And they're going to file a shareholders lawsuit. And if they win that lawsuit, that's going to change the whole game. Now, is that going to happen this year? Probably not. Next year? Probably not. But it's going to happen sometime. And we're going to start to get cases. I was up at Harvard yesterday at a thing about benefit corps that the B-Lab founders were at, and the Chief Justice of the Supreme Court of the state of Delaware was there. The Delaware jurisprudence has always been totally hostile to any of this stuff. If you're a Delaware corporation, shareholder primacy is it. And they have a whole line of cases that say if you're a director of a business corporation, the only thing you're allowed to take into consideration when you run your company is maximizing return for shareholders. That's it. And that has been classic Delaware law for a long, long time. Delaware now all of a sudden introduces the benefit corp, and I was a skeptic, and I said, I guess they're doing it, but it runs contrary to the way this whole corporate jurisprudence has been in that state for 30 years. What does that mean? And the Chief Justice of the state Supreme Court got up and he said, this is a game changer. And the reason this is a game changer is because when you form a regular business corporation, the deal is that the corporation is formed to benefit the shareholders, and that's it. But when you deliberately put into your documents that there's another purpose to the corporation, and people invest in that company and they do business with the company knowing and with the expectation that that will be fulfilled, that the courts of this state are going to absolutely enforce that bargain, and we're going to stand behind it 100%. I was not expecting that. So when you start to see courts in Delaware, which is the forum for businesses in the United States, start to enforce some of these restrictions and give it some real teeth and meaning, that's all going to be a game changer. So we're all impatient and we'd like to see it happen tomorrow, but in the real world it doesn't happen. I think what Neil said is absolutely right, which is this is a direction that business is going anyway. You see it everywhere. You see it in cause marketing. You see it in, Clorox with the green products and this and that. You see it everywhere. Companies want to be seen as good corporate citizens. And in my practice, among other things, I'm talking to a bunch of fairly mature companies that had been operated in this way long before there was ever such a thing as a benefit corp. And the founders of those companies are now looking and saying, how do I embed the legacy of the way I ran this company so that when I leave and the next generation of owners come, and I don't know who they're going to be, and they may or may not care about the same things that I care about, how can I embed those values into the company in a way that's going to stand the test of time? They all are talking about benefit corporations. So let's have the conversation in 2 or 3 years.
Dana,
Yes,
if I may, I just wanted to agree with what you and Emily said at the beginning about I don't mean this pejoratively, but the relative weakness, shall we say, of the benefit corporation statute as perhaps a little more than just a statutory phenomenon. And the question that you asked was, what will it take to get beyond the status quo? Is it a question of consciousness raising? And I think one of the questions that I had before I came here today, and I didn't have enough time to research the data, is to what extent do benefit corporations find it more difficult to find external funding simply because of the fact that they're benefit corporations? Picking up on one of Alan's points, if there is still some degree of uncertainty with respect to the structure, then that's going to affect the quality of the deal. And I think I'll give a rather glib but I think accurate answer. When the first benefit corporation does an IPO or sells out to Google or Facebook or something for an excess of $300 million, people will be banging on the doors of benefit corporations. Until then, I think it's going to be still a question of consciousness raising.
So I wonder, Neil, if I could ask you a question about financing, since you brought up financing. It seems like governance, what the benefit corporation is trying to do, is one way to solve this kind of problem of how do you embed a dual mission, how do you get the founders and the investors to come to some kind of enforceable agreement. But it seems like financial tools is another way to do that, at least for a relatively lengthy period. And it seems like in the startup area, like you said, be very careful in guarding your equity. Even outside of the social enterprise area, that's good advice. And for that reason, you see a lot of convertible debt in that space. And I've been working on with my co-author, Stephen Dean, who's also a BLS professor, and I hope the other person that Jonathan was alluding to earlier, on a lot of work on financial products that could try to embed that. And I wonder if you think that convertible debt is a good way to kind of create enforceable promises between parties who have both in mind a kind of dual mission but aren't necessarily ready to trust each other.
I think my answer is yes and no, more yes than no. Especially with startups in angel or seed stage, convertible debt is increasingly the way to go. For you lawyers out there who want to do startup work, guess what? You've just been disintermediated by Y Combinator. They've come up with convertible debt documents that work for about 80% of the standard angel or even perhaps seed stage investments. But having said that, I think convertible debt is a good way of doing it because within the context of that you can have all sorts of covenants, both positive and negative, that can be enforced. You could narrow, one of Alan's points is that the social mission of a benefit corporation can be, especially for example in the New York statute, it can be extremely broad. And someone comes in and says, I wanted economic justice, and someone else comes in and says, no, I wanted housing, and someone else comes in and said, no, I wanted environment. You can tailor the social mission that much more that way in the context of a convertible debt document. On the one hand, the no part is that the convertible debt will likely convert. The objective is for convertible debt to convert to equity at the subsequent round, which presumably is the round at which someone, perhaps more professional, is going to be valuing the company. So the no part is A, there is going to be some level of dilution, and B, for those of you who are not familiar with convertible debt, what happens in a convertible debt situation usually is that you agree to lend the company money at a specific rate of interest and that it is convertible into equity either at a fixed rate then or more commonly now at the fixed rate of the next round of investment or a premium to that. In other words, if the next round comes in and values the company at $1 million, you get to convert at a 30% premium or a valuation of $1.3 million. The extra swing in the valuation on the convertible debt, I think, can be a real issue vis-a-vis equity. But otherwise, in general, I do think that that convertible debt could be extremely helpful as a financing tool.
Jonathan, do we have time for questions?
How are we doing? We're over time, but let's do a quick check. Our next caller is Skyping in, so I don't want to keep moving too long, but let's do a couple.
I was just curious to know what your views are on social impact bonds or the potential in that area. Can you say something about that?
This is whom?
To you or to whomever.
All right. There is, and Holly is well aware of this, there's an entire social investment vertical, for lack of a better word, of which social impact bonds are a part. There are venture funds that are B-Lab certified, like SJF, for example. I've never done any work on social impact bonds. I just know of them generally. I think that to the extent that these people can manage to, that this entire vertical can manage to produce good economic returns, people will ultimately be seduced by the ability to do well and do good. And that's my view of that, sort of that entire vertical.
It's really a brand new thing. It's very much like this. There have been very few bonds actually done in
They're
the
also
US.
not bonds. I
They're
mean,
not.
it's really
You're
just a
right.
marketing
Well,
term.
that's
It's
right.
a
They're
pay
not
for
bonds.
performance contract. It's
That's
really
right.
not. It's really a new, a new label on an old concept of pay for performance government contracting. But the idea is that the private sector is fronting some of the cost. That's the new.
The investors put up money. So let's say you have a nonprofit, and they have a government contract that says if you can reduce literacy by 10%, we pay you $1 million, or whatever the metric is.
Increase literacy, probably.
Increase. Yes. Sorry. But the idea is that the government wants to pay for results. It doesn't want to pay for effort. And yet, it requires capital up front. So the government doesn't want to say, well, here, we'll give you the $1 million and hope you do something good with it. They say, we'll agree to pay you $1 million if you can achieve this result. And so private investors will come in and lend money secured by that promise to pay. And if the nonprofit can perform what it says it's going to perform, it then gets paid by the government, and it repays its investors, and it pays them a profit on their investment.
So our next speaker is Canadian, so that means he's very politely been waiting on Skype for us. I'm going to allow one very quick question beforehand, though.
This will be quick. Neil and Alan, you both spoke about the nonprofit hybrids, like a church or a church or museum having a gift shop or some other business which is definitely making profit for the nonprofit. If you could talk about the structure and taxation, National Geographic has a cruise business, etc. There are a bunch of these examples, and I'm sure I'm not the only person in the room who's always wondered about what's the structure and tax structure of these enterprises.
Yeah, it's not a quick
I was
question.
thinking
Maybe you can follow up with them later.
The short answer is there's something called unrelated business income tax. So if the 501c3 is getting revenue from an activity which doesn't substantially further its charitable mission in and of itself, that income is taxed at normal corporate tax rates.
Well, please join me in thanking our panel very much.
Thanks, Dana. Thanks, panelists. Great. We're going to now turn ourselves back to Skype. Is Joshua out there? Our next speaker, I've sort of been on the lecture circuit with him, I guess. We spoke both at the last Legal Hackathon, and we also both spoke at an MIT Legal Studies Salon. And you remember a couple years ago, I think Dan Katz wrote an article, a bit tongue-in-cheek, about MIT Law School. And I don't think anyone was appropriately scared of what that meant when the technologists try to really disrupt legal education as well. In any case, Joshua gave a terrific presentation there. He's agreed to grace us with his quick words of wisdom here. Josh, can you hear us?
I can. Do you hear me?
Yeah, we hear you great. I'm handing it over to you now. It's called Technology for the Long Haul.
Hi, everyone. Thanks for letting me come and join you today. I'm going to really quickly jump over to a quick presentation, and then we'll begin. So I wanted to talk today about technology for the long haul. And I think with all the great innovation that's going on in technology, lawyers may be in danger of falling into a trap. About 1,300 years ago, the Lindisfarne Bible came out. And it's a phenomenal piece of illuminated manuscript. It's been preserved through Viking raids and Wars of the Roses and all these great changes that happened in England throughout history. And it's now been digitized and placed online for us this week. Something has been preserved through the ages. But if you look at technology and how we're advancing right now, this came out 20 years ago. The iOmega zip drive contained about 100 megabytes of data and owned the marketplace. People were backing up their information left, right, and backwards on this thing. And right now, you couldn't This was Mary Eileen Donovan, the manager for the Justice Management Division of the U.S. Department of Justice. What's interesting is New York courts still use WordPerfect to this day. If you go to newyorkcourts.gov and jump into their form section, right there on the far right is WordPerfect documents. And this is from the family law section. I don't know any person out there that could get a temporary order of protection from the family court if they were required to use WordPerfect right now. What we've done is we've created a system where we put data in silos. And a very well-known technologist, James Schofield out of the UK, has drafted what he calls his first law of computing. He says, never put data into a program unless you can see exactly how to get it out. Which is a great rule of thumb. You don't want to rely upon proprietary formats and databases, but what we're seeing over time, and that's what I think the WordPerfect and the iOmega disk examples illustrate, and this is Lennon's addendum, is that the passage of time will make almost every electronic file format inaccessible. We're putting ourselves in a position where, unfortunately, we put our data into silos, but then we set those silos on fire, bulldoze them into the ground, and salted the ground, and left a bunch of scorchers behind us in our race to grab the next best software, the next best file format, the next best iOS system. How many of you right now are typing on an iPad, and how many of you can pull documents from 5 years ago onto that iPad quickly and easily and in a legible, usable format? Just think about it for a second, because that's the trap in which we're all falling. That the next product that we use is not necessarily something that preserves the information that we need from the past. This is especially a problem, though, for lawyers, because we have a duty to produce electronic documents decades from now. And so the document you produce this week should literally be accessible decades from now. And you think I'm joking, but let's take a look at New York in particular. Lawyers need to produce on-demand financials and trust records 7 years from the date of creation. But you also, and this is from the New York State Bar Association, have to produce original client files or original copies thereof of original wills, files involving minors or those under disability, so that could literally be 18 years from now, or the lifetime of the person under disability. Select real estate files. If we look at real estate files in New York, those easily go back decades. And family law matters involving future expenses. These are all examples given from practice management guidelines by the New York State Bar Association. Their best advice is to use common sense and err on the side of caution, which seems to me to be saying, don't throw away anything, oh my, we're going to need it at some point. And this advice doesn't even take a look at statutes of limitations for malpractice claims, which in New York tend to be 3 years from the date of occurrence, but under the continuous representation idea, could mean that the lifetime of the representation and the actual occurrence of the event are vastly different in scale. And so to protect yourself, again, you're going to need to be holding on documents in a usable, producible format. If we jump across the pond and take a look at the Law Society of England and Wales, they give 2 very clear definitions of how long you should be retaining certain types of files. For trust, it should be the life of trust plus 6 years. And within the document in which they describe this, they're very clearly talking about examples where there may be a remainder from the trust that revert after the lifetime of the life of the trust. And so then you have the lifetime of the trust target plus 6 years. It's almost a law of perpetuity happening right there. And with wills, they give you 2 options in their guidance. One is keep it indefinitely, and the other is some law firms keep it 50 years from the date of creation. But again, and this is an exact quote, you should be erring on the side of caution, which seems to me to be indefinitely at this point. And they even state you should be keeping a copy of a will even if you know it's been revoked, because if there's a dispute on a following or subsequent will, and that will is declared invalid, then the revoked will now come into force. And so you, as a representative of your client, need to be producing these documents decades from when they've been created. And in electronic file format, that can be a huge problem. And so lawyers who are relying upon software that uses proprietary formats that run on Windows XP are now going to be forced to either turn into, hopefully, some type of emulation software, or may not be able to access that software at all. Can you say your client's files are safe with you for the next 50 years? If you can't answer that question, then you've created a problem. And the current solution to that problem is warehouses. Warehouses of boxes and boxes and boxes of paper, which does not jive with the idea of increased efficiencies and means of serving our clients that become better suited towards our digital lifestyle. And so I've been researching this quite heavily, and I think the answer is the lawyers should be using improved document standards to ensure access over the span of decades. And the question of where to grab those improved document standards is really still somewhat up in the air. There's only one real place to turn to for this right now, and that's the International Organization for Standardization. Since the 1940s, they've been coming up with worldwide proprietary industrial and commercial standards out of their headquarters in Geneva, Switzerland. And a good chunk of the time, this applies to mechanical processes. So we see a lot of different gauge standards coming out here and measurement standards. But they do have a couple of standards for document and knowledge preservation that I think should be becoming the basis by which lawyers and law firms preserve documents from now to the next 50 years. And those three standards are ISO 1905, ISO 29500, and ISO 9075. They relate to three things that you're probably using right now, but you may not be using them to the full degree that you should be to preserve your client's information for the future. Let's take a look at the first one, ISO 1905. You'll be familiar with this as a PDF-style document, but it has a couple of key factors included in it that you may not be using. The first of which is embedding your fonts in the document. And most of us don't do this for one simple reason. It makes for a much smaller file size. But if you're not embedding your fonts in the document, then what that document is doing is relying upon an outside file to control its presentation and format. And that may not exist or be accessible 2, 3, 5 decades from now. So under ISO formats, you should be checking the box that says embed fonts in this file. And the second thing under this ISO standard is that there is no encryption allowed. And right now, with all the talk of the NSA and Edward Snowden snooping that's going on within a lot of the legal space, the idea that we should be foregoing encryption is actually somewhat controversial. But when you think about this, encryption of your files would mean locking away access rights. And if you are the only person who has the key to unlocking the encryption of your files, what you're actually doing is preventing your clients from having access to that file at some point in the future, potentially. Either because you no longer have access to the encryption software, you no longer have access to the key, or your clients may have access to the file but not have access to you. And if you are locking your files away, you are creating a situation where you are violating your ethical obligation to provide access to these files in a format that is producible and usable by the courts and the clients. If we take a look at the second standard, this one is controversial in its creation, and that's the Open Office XML standard. It was created by Microsoft and kind of pushed upon the the standard community. And it's actually against some other open standards that are out there right now, like the Open Document Format, or ODF format. What's interesting about it is it's based on XML architecture that's an extensible markup language. It's pretty much the exact same language we see being used to create types of web pages, for example. What's interesting about this is lawyers have access to this file format now, but for the most part, law firms aren't using it. We're all saving it in older formats, the .doc or doc format, when we should be saving all of our documents right now into this extensible markup language. And so we should be using the ending .docx. The X is for XML. And if you're not saving your documents in these formats, then again, we're going to be seeing decades from now, depending on the next brand of software that becomes popular, whether it's an Apple product like iWorks or a cloud-based product like Google Apps, they may not be able to open these documents, and you suddenly spend a lifetime preparing yourself for a malpractice claim and you can't defend yourself against. one thing that neither of these options really deal with, though, is numbers-based. And numbers calculation is becoming a larger and larger component of both litigation and transactional work. And so the only ISO standard out there right now that helps deal with the storage of large volumes of data and the manipulation of numbers is probably the SQL standard. And this is a database architecture that exists at the back end of a lot of services that we use. My own company, Clio, for example, we store a lot of law firm information in SQL databases. And the reason it's important to have this is we do know that you'll be able to both access and manipulate this data in the future. And so if you're not looking at these standards and using them as the bedrock on which to build your producible work product, you're going to be putting yourself in a situation in which you cannot be meeting your obligations to either the clients or the tribunals before which you serve in the future. And so I think the takeaway here is that when evaluating technology now, lawyers must not just evaluate it on the efficiencies by which they will be gaining it, but they should also be evaluating it on the exit options that are presentable from it. So we've talked about some great uses for technology right now for lawyers, and the things that we can be doing with them to gain efficiencies in the criminal justice system, access to justice for lower income people. But as we pull that information in, we should definitely be taking a look at when can we exit that information and can we do so in a way that meets our obligation as legal professionals. So that's my quick spiel. I want to thank everybody for letting me take time to do it. If you have any questions, you can reach me at a variety of different ways, including my email, Twitter, and LinkedIn. And I'm happy to be carrying this forward because I'm not seeing a lot of discussion either in both big law or tiny law talk about the idea of longevity in legal technology as well. So I'll turn off the screen and pass it back to my handsome mug and see if there are any questions.
Thanks, Joshua. I think that's a wake-up call to a lot of us in this room, both practitioners and soon-to-be practitioners. I should also tell, by the way, I just started following Joshua on Twitter. It's a great resource. Highly recommend.
Thank you very much.
Sure. And students and I are also experimenting with his Go Clio law firm management tool. So.
That's great. Thank you. Yeah, I hope that's going well. If there's any questions, let me know how I can help.
Thanks, Josh.
Any questions from the audience on picking technology? The average lawyer tends to practice till about age 72. Are you picking tools today that will support you in that?
We have time for one question. I see a hand. First hand, that's where we go.
I'm just wondering if you have any suggestions for batch conversions, if you have a whole bunch of files that are already in doc format or something like that, if you have any software recommendations.
Actually, I don't. That's part of the problem. So we have entire law firms that are locked into WordPerfect because that's what they bought in the 80s. And they're having to go through a manual conversion process with a lot of formatting no longer being preserved. So I think what you're going to have to do is take a look at services out there that are already doing batch conversions for archival purposes, usually for museums and government services. And maybe we'll see law firms and a new business initiative come up on digital data preservation for the legal sphere.
So you know what I heard there? Joshua said problems. I heard opportunity. I heard a potential venture that explores that niche market, batch conversions for law firm documents. All right, so I think we're running behind, so I think we should have our alternative approaches to funding litigation crew come to the stage. Over the years, I know at least I'm sure a lot of you have. My students and I have been exploring different ways to crowdfund noble litigation, both on the plaintiff side and the defense side. Imagine a lawyer who wanted to take on a very worthwhile 1983 action, but it was somewhat suspect. Wasn't sure if he'd ever actually be able to win the case. If we could crowdfund that 1983 action so that the lawyer would have some certitude of getting some money up front, I think we'd see a lot more courageous attorneys out there. In any case, I think we've got a terrific panel of experts here that have explored different aspects, different models for alternatively funding litigation, both on the plaintiff side and defense side. I'm handing it over to Steve Reed from Northwestern, who's done a lot of academic work on this, and also works very intensive. Actually, wrote a book that I think we'll be using next year, Entrepreneurship in the Law, textbook.
Thanks. Thank you. Testing. Can you hear me? Yeah. Well, anyway, it's. Oh. That's all right. Anyway, I think I don't want to speak for anyone else, but this has been a really fascinating day, I think, and in many ways inspiring. So congratulations to Jonathan and also Dave and Mike and all the organizers. It's been fantastic. And I think that's going to continue with this panel where we talk about funding legal processes. If this is a topic that interests you, then you probably already know the panelists who are up here and know that we're in for a great talk. If this is not a subject that interests you, then I would say the same thing I said to my girlfriend before she became my wife, which was, let's just give it a try. I promise it won't be boring. The format will be this. We're going to kick off with hearing from Sean Coffey, who's going to sketch out what we mean when we talk about different ways of funding legal processes and litigation specifically. And then we're just going to have a discussion, the four of us up here. I've got a few questions here, and hopefully you have some questions too. I think the scheduled end time for this panel was 4:15. We'll probably run a little bit more than that. But in any event, hopefully it will be a lively conversation. So can we get Sean's PowerPoint, or is it already?
Well, while it's coming up, good afternoon, everyone. It's a pleasure to be here. Just a quick background. I have been a large firm litigation partner. I've been a plaintiff's lawyer, and I have also been in the lit funding business, and I'm now back to being a litigator. But I'm a big believer in the space, commercial litigation finance. And what I'm going to do to kick us off is give you sort of a primer, the basics, and then we'll be talking about aspects of what CLF, as I like to call it, can do for companies, for law firms, et cetera. So with that, what is commercial litigation finance, or any litigation finance? It's a transaction that gives a third party other than a lawyer a financial stake in the outcome of a legal dispute in exchange for cash paid to a party to that dispute. Now, litigation finance is both relatively new and it's also very old. If you take out that parenthetical, what you're looking at is the contingency fee model that's been around for 100 years. So commercial litigation finance, the idea that a client can bring a case without actually laying out money or offloading risk, if you will, and cost to someone else has been around for 100 years. But it's been in the exclusive domain of a very narrow section of the bar, the plaintiff's contingency fee bar, which, I'm here to tell you as a former plaintiff's lawyer, the rumors are that they make a lot of money, and those rumors are true. And it's in part because of this incredible inefficiency that the plaintiff's bar is able to exploit. I'm now a partner at Kramer Levin, and my conversations with my clients are typically, how much of a discount off my hourly rate will I give them? When I was a partner at Bernstein, Litowitz, Berger, and Grossman, we looked at cases to see how many times my hourly rate will I make on this case. I don't think I'm a worse lawyer than I was a few years ago, but there is this real disconnect. And what's exciting about commercial litigation finance is it's an opportunity to exploit that inefficiency for the benefit of clients who might otherwise have to pay more to plaintiff's lawyers, for society, I would say, because it allows David to fight Goliath on a more level playing field. And it's just a market solution. So it's old and it's also new. It's also a good investment, by the way. I think investors are starting to figure that out. So first, there are basically three types of litigation finance. Consumer. We're not going to talk about consumer very much today. Am I on the right? Okay.
Oh, no.
All right. Sorry about this. There are three types. There's consumer. This is forward. Got it. There we go. Thank you. There's consumer, which is more like the personal injury. You might have heard of some of these outfits, 1-800-LAW-CASH or something like that. And it's more of an actuarial play where they put a lot of money out a little at a time. I think their average is something like $1,700 a case. and it's primarily a loan. There's also law firm lending, where a funder might loan a law firm a chunk of cash and have as collateral its docket. And then there's commercial litigation finance, which is more of a one-off, case-by-case basis, lots of underwriting, and I think that's where we'll primarily spend our time today. With regard to commercial litigation finance, I thought I'd give you some of the criteria that goes with the typical transaction. The cash that's given to the company, and that's typically how it works. The funder will provide funding for the company. It's usually couched as an equity investment as opposed to a loan. And what's happening is the funder is buying a piece of this claim. It's usually non-recourse, meaning while the only recourse for the investment is the cause of action, is the lawsuit, and that if they lose the lawsuit, they can't turn around and ask the company for the money. Very important. The contract is between the funder typically and the company as opposed to the law firm. This is important for purposes of independence and judgment and fee splitting and things of that nature. This investment range can vary widely, but it can be as little as a few $100,000, or it can be very significant. It can be doled out as a lump sum in the beginning or drip fed over the course of the case. One thing that's very significant that's different between consumer and commercial is that just about every deal in the commercial context, the client, the corporation that's taking the investment, is a sophisticated consumer of legal services. So, the U.S. Chamber of Commerce likes to attack litigation finance as somehow exploiting the fundee, as it were. But again, these are folks who are very sophisticated. And the money can be used either to pay the litigation fee as it goes, or it could be that some entity wants to take money off the table now and use it to build a factory or for some other corporate purpose. They have an asset It's an unliquidated litigation claim, and they're basically willing to take $1 today that they can use today in return for giving the funder $4 or $5 down the road. That may or may not actually happen. Very important. Funders typically do not give legal advice, even though they're frequently ex-lawyers and understand the legal system. They are not giving advice. They're businessmen. I'll go through these very quickly because I know we have a lot to say in a little bit of time, but there are funding advantages for companies. They can pursue claims they might not otherwise be able to do, and they can hire the law firm. The basic deal, there's sort of two models. There's the old model, current model too, of paying by the hour, which clients don't like because the lawyers don't have any risk. And then there's the contingency fee, which a lot of companies don't like because they have to hire plaintiffs' lawyers, and they don't like them. Commercial litigation finance offers a way to bridge the gap. You offload the risk and the cost to a third party, funder, and you use the money that you get to hire the law firm by the hour that you like. For law firms, it's also an advantage because there might be cases brought that might otherwise be brought. They'll get paid regularly. They get a cross-check on the merits of the case. And the last thing I'll say before I stop, it's very, very important to understand that there are a whole bunch of rules that could apply and do apply to commercial litigation finance. There's statutory rules. There are some states in our country where it's illegal to do what lit funders do. It's a crime in Mississippi. That's tied to the civil rights era and trying to keep people from helping the NAACP, but it's still on the books. You have court rules. In some jurisdictions, you have to disclose all the parties with an interest in the case. Okay? Query, do you have to disclose the existence of the funder? And then you have the ethical rules in the state by state. What are the lawyer's responsibilities vis-a-vis the client if a funder's involved? Certainly not going to go through those, just flag them. For every investment in each of our 51 jurisdictions, you have to figure out all of those rules and how they interact with each other. So it's complicated, but it's very exciting. It's a terrific new area, and now I'll turn it over to someone who's actually still doing it, and doing it well. Travis.
Well, still doing it anyway. Thank you very much. My name's Travis Linkner. It's a pleasure to be here with you this afternoon. Thanks to Steve, who's a colleague of my wife's at Northwestern University on the faculty at the law school, and to everyone who had a hand in organizing today. I did want to say I was sorry for not being here for the rest of the day's sessions. I flew in from Chicago today. So I spent a little time at LaGuardia, which is appropriately Dickensian. So you have a Bleak House theme, and that's the only real link that I have for you. But the D gates are grim, and I was there. I'm a managing director at a litigation finance fund called Gershon Keller Capital, based in Chicago. We launched at the beginning of 2013, and as of today have a little over $300 million in assets under management. Those assets are dedicated to commercial litigation funding arrangements of the sort that Sean described. By commercial litigation, we mean business-to-business litigation with a corporate entity on the plaintiff's side as well as the defendant's side, and we mean a situation where our counterparty, usually the company but occasionally the law firm, is a sophisticated organization and someone with experience in the litigation space. Our average investment size is somewhere between $3 and $7 million, and those funds typically are used to pay for legal expenses, so attorney's fees and or out-of-pocket costs like expert witnesses and e-discovery vendors and things of that sort. But sometimes, excuse me, as Sean mentioned, those dollars can also be used as working capital for the company or the law firm. And they are non-recourse or limited recourse arrangements where generally our recovery is premised on a successful outcome in the litigation. One other quick thing to mention is that we are interested in funding on the defense side as well as on the plaintiff side. So our view is as actually positioning ourselves and others in this space as financial services providers to companies and law firms that are involved in commercial litigation, whether they are a plaintiff or a defendant. To expand just a little bit and then turn it over to Chris and hopefully have an engaging discussion here and with your questions, but to just expand just a little bit on the value propositions of commercial litigation funding, both for companies and also for law firms that become involved in these sorts of transactions. First of all, just very quickly on the company side, the very basic way to categorize the companies that might be interested in commercial litigation funding is just to split up companies and call some of them small and the rest of them large. So from the small company perspective, it's fairly easy to see what the incentives might be to look around for commercial litigation funding alternatives. You have a well-financed defendant that is capable of going the distance and is going to hire an AmLaw 5, 10, 15, or 100 firm to punish you in discovery and take you as far down the litigation road as they can. And so it's necessary to find a firm that is suitably equipped to match them on the plaintiff's side. It may not always be the case that you can find a firm that would take your engagement on a contingent fee, or that the firm you want to work with is a firm that offers contingent fee sorts of arrangements. So as a small company, you might need to pledge some of the contingent receivables in the litigation in exchange for finding counsel in the first place to represent you. As a large company, you might say these are companies in some cases with billions of dollars in cash on their books. Why on earth would they give up a portion of their potential recovery if they were a plaintiff in a commercial litigation matter? The short answer is there are actually a lot of reasons that they would, and I'll mention two. One is quite simply that the larger the organization, the more internal agency issues present themselves. And so the litigation budget or the law department budget is what it is, full stop. And for a company with $2 billion in cash, but $50 million to spend on litigation or legal services in a given year, most of that $50 million is already spoken for in fighting wars of necessity, that is, defending the company against litigation in matters where it has to defend itself, as opposed to fighting wars of choice on the plaintiff's side. So very frequently a general counsel and almost more frequently a chief financial officer might say, gosh, instead of spending another $5 million to bring this action, which we might not win, and so that might be $5 million that just hit the P&Ls and we lose that money forever, perhaps we should go and get the counsel we would have anyway, and because they don't want to offer a full contingency, we'll give up the standard 35% that we would be giving up if we did have a contingent fee law firm. we get to work with our counsel of choice, and we're no dollars out the door to bring this piece of litigation. If we win, it's found money, and if we lose, we aren't out anything. We haven't spent corporate assets above and beyond the legal budget to go and bring this claim. The other quick incentive for large companies is more of an accounting issue, and Sean alluded to it. If you have a litigation claim, you have an unrecognized or unliquidated asset that doesn't actually show up on the books. You just have a claim. If you, by contrast, have a coal mine, you can go and buy a lot of earth-moving equipment to move the dirt and get the coal and extract it and sell it. And those are capital expenditures. There are lots of accounting and tax incentives for buying all of that heavy equipment. The same incentives don't apply when you go out and hire Cravath to bring a piece of litigation on your behalf. Every dollar out the door to pay the law firm immediately hits the P&Ls. It affects quarterly earnings, and Wall Street pays attention if you blow that number by even a penny, and they don't care if your excuse is, well, we were chasing $100 million in a breach of contract case that we think we might win in 4 years. It's actually a pretty bad answer if that's the situation in which you find yourself. So frequently companies, even large companies, will look to funding arrangements to solve that sort of issue. And then just very quickly to speak to law firm incentives, the whole theme of today is to look at lots of different ways, and funding being just one of them, where entrepreneurial lawyers are changing the space for the better. And for some of the folks that we talk to, I will just say that entrepreneurial means finding more people who want to pay you by the hour using the same model we've used for a really long time. That's not the way we think of it, but that's the way some other people think of it. And so one incentive for law firms is if they are looking to take a bit more risk than they might take today. So a firm that frequently represents corporate defendants, very rarely takes plaintiff side engagements, but also almost never takes contingent fee matters on the plaintiff side. They might say, well, we're interested in taking a small portfolio of contingent fee cases because our clients are demanding these alternative fee arrangements. We don't know what that means, but we'd like to figure it out and try to meet those demands. They can partner with a funder who will come in and underwrite a case and share the risk with them in order to give the client a risk-free engagement on the plaintiff side. That is, the client is out no dollars today, but the law firm is getting some money in the door every month in exchange for its time. So the firm is basically able to give the client a full contingency, while the firm can basically see it as a 50 or 40 or 30% discount, with the funder taking an equal or possibly larger share of the risk and allowing the firm to have some revenue during the time when it's paying salaries and other costs to actually bring the case. So that was supposed to be very quick, and it wasn't, but that's a short picture of some of the incentives that we see in the market, and I'll turn it over to Chris.
Hi, so I may well be the odd man out here. For a little background, I am a third-year law student here at Brooklyn, and I coordinate the Patent Troll Defense Network, which is administered by the App Developers Alliance, a trade association out of DC. So a lot of my work is involved on sort of the alternative means and methods with which people raise funds for litigation. Patent Troll Defense is it's a very asymmetric system wherein costs are high for both parties, but costs are generally higher for defendants than plaintiffs. And many times defendants are, as you mentioned, smaller businesses, unless we're dealing with, at least the ones I deal with. We're not talking the Googles and Apples of the world. I'm talking usually single inventors or small startups in the app space. And so a lot of them can't afford to go through the actual process of litigation and need to find some means to finance that. There are your sort of standard well-developed means, and then there are newer ones like the most recent sort of equity investment process the SEC has been talking about recently, equity crowdfunding, and then your various legal defense ones. So that's sort of what I work in. I'll keep that to there, and we can actually maybe have a discussion or take some questions too while we have time.
Okay, great. So if there are any questions at this stage, we can. I've got several.
Okay, we've got a bunch, but while I walk to people who have questions, I'm going to take Travis to task. Didn't you know what happened to Joe Biden when he slandered our beloved LaGuardia Airport? We're going to have you bound and gagged and shoved in the trunk of a Buick before you leave this place.
The flight is already delayed an hour home, so I'm paying for it, even though, yes.
So what level of control or input do the loan providers or the fund providers have over law firm selection, like guidance to the client? Like what sort of impact do you have?
Great question, and the answer is it depends. But when lit finance first started, and it really started in Australia, other than we're talking about commercial litigation finance, but Australia, then it spread to the UK, where it's very well developed, and it's been here 5 or 6 years. And it was very conservative. In fact, they touted themselves saying, we have nothing, hands off, totally hands off. What at BlackRobe, my former outfit, we call the passive approach, or lit finance 1.0. It's different now. I think folks are more comfortable with it. And the ABA Commission 2020 on ethics came out with an opinion a couple of years ago. It was very helpful. And if you think of a lawsuit, of a litigation claim as a bundle of sticks, and each stick is a right. You have the right to pick counsel, fire counsel, be informed about what's going on, settle the case, bring the case, et cetera. If you think of it as a bundle of rights, and I'm converting what the ABA said into something, as a trial lawyer, I think I can convey. The ABA basically said you can sell one or all of those rights to someone else for consideration. And so you can sell to a funder the right to control the case. Okay? You can't do that with a lawyer, because a lawyer has ethical prohibitions against that. But a funder, you can. And so it depends on what you bargain for. And let me use another example. No one would have a problem with the following. I own a company, I have 100 shares. I have one asset, my litigation claim against Acme. All right, I could use some money now. This is a great claim, but I could use some money now. So I go to Travis and I say, Travis, I want to sell you 33 of my shares. Okay, I still control the company, but Travis says, the only asset you have is this fund, this claim, so I'll give you the money for 33 shares, but I want the right to bracket settlement or control settlement. No one would have a problem with that deal. Okay? Because it's, I'm able to sell. And the ABA basically endorsed that approach. And so you can't do it with a law firm, et cetera. The reason you want to be in privity with the client and not the law firm is because of things like independence issues. Is a law firm doing this because they need to please the funder or the client? And so it depends on case-to-case basis. Maybe Travis has experience, but what you're doing in this business is assessing risk. And from my perspective, you reduce risk if you can actually have a say on settlement. And you just end up paying for it.
So I'll just say that Sean's exactly right. There's a pretty wide spectrum, both of what's permissible and of what people believe is permissible. I think that's fair to say. As a matter of conservatism, and also the fact that we tend to limit ourselves to larger dollar commercial cases, we still follow the philosophy of passive capital. So we have information sharing rights. We look like a non-testifying expert or a litigation consultant in the sense of being on the sidelines, having a voice in strategy, having the right to know about a settlement offer before a decision is made, but not having any contractual right to say, you must take this, you cannot take this settlement, you must make this argument, you must raise this claim, etc. So from our perspective, then you mentioned counsel, diligence on the front end is incredibly important, not just about the quality of the claim, but also the quality of the lawyering, who will be primarily responsible for the case, the background of the firm, and so forth. But we take a passive approach.
So do you get situations where a particular funder will have a good relationship with a particular firm, having worked with them on a few different litigations, and build up that kind of trust, or not really?
Sure. I mean, BlackRobe was around for about 2 years, and it's no longer around or active for a number of reasons that have nothing to do with the space, just more startup personality issues. But certainly, when I started it, I know a lot of folks in town and visited with them and know good lawyers, and they were there's a lot of interest because the big firm model has issues, challenges, it may be broken. And so there's a lot of interest in this alternative to maybe goose profits. I've been back in the big firm practice now for 4 months, and I've had already three terrible conversations with clients about our bills. And I remember how I hated this. And so if I was able to say to a client, listen, your legal budget is zero, because I had a funder backing us in a law firm lending context, it would be I could see the attraction of it. So anyway, Travis.
No, I think we primarily see inbound opportunities from law firms, not from companies, not because our counterparty ultimately is the law firm, but because the attorneys are just working with the client to find solutions to allow the litigation to continue, or for whatever reason. So it frequently is the case, much as it is with your IT providers and your demonstrative graphics providers and all the other service providers that law firms use. They're fairly sticky, and particularly in this new and emerging space, they want to have a good understanding of who they're working with and who they're introducing to their clients. Mm-hmm. So yes, to the extent we can develop good and deep relationships with law firms, that's a great thing.
Yeah, one thing that the ABA Commission paper I referred to before from February of 2012 does flag as a potential issue an ongoing close relationship between a funder and a law firm as something that could give rise to some independence issues. Just FYI.
That's my question. I've been doing this for 38 years, and on my cynical days, I don't care to take advice from an organization of prostitutes. So the ethical restrictions on private investment in law firms really don't move me particularly. In the UK, they apparently don't move them enough so that it's allowed. You can now privately invest in law firms over there. So I don't understand why we don't do it here.
Yeah, you lost me after the word prostitutes. I'm still.
I got distracted.
I know there are certainly differences. In the UK, law firms solicitors are required to tell their clients about the availability of lit finance. And here, we're still, or you are still pushing to get it more widely accepted. I think part of the Ethics 2020, to get right back to your point, there was a parallel effort to talk about allowing investment in law firms. The paper on lit finance made it through and was published. The one on allowing investment in law firms was strangled in the crib, as it were, and never saw the light of day. So it's just a really, really sensitive issue among the bar, or the powers that be in the bar, and so it didn't even get out of committee, or it didn't get out of the process.
I guess I would say if you come at this space as we do, my partners and my backgrounds are all from law firms that traditionally represent companies on the defense side. And by saying we're only doing commercial litigation, the way we define commercial litigation finance is to say on the plaintiff's side we aren't funding consumer class actions, products liability, securities fraud, a lot of the types of cases that are partly or largely responsible for a reputation of the plaintiff's bar, if you put that term in quotes. One inequality that persists because of the rules about non-lawyer ownership in law firms is that lawyers on the plaintiff's side who have been very successful or have hit it big in a couple of cases, legitimate or not, now have a very large war chest that they can use to perpetuate whatever sorts of suits they might want to bring against corporate defendants. So from the point of view of the people who turn to us for funding, it is frequently small and mid-sized companies. Those sorts of plaintiff's lawyers aren't the plaintiff's lawyers who would be representing these companies in their disputes, but these companies need financing solutions and ways that they can have access to the courts where they're basically caught in the middle of a spectrum with pure contingency fee trial lawyers with millions of dollars of personal wealth that they can now use to bring new cases on the one end, and AmLaw 100 law firms that only charge by the hour and are very expensive on the other end. And a lot of the companies we work with sit right in the middle. So the funding that we provide is partly a solution to an access issue for them that is created somewhat because There is not non-lawyer ownership in firms that would allow firms themselves to stake companies like this and bring in those sorts of cases. And I know for the people and companies that Chris works with, I think it's a very similar profile.
Yeah, building from that, on the defense side of it, there are many entities and corporations that we work with that are so small that maybe their only assets are a single patent or their invention or their creation or not a provisional patent, which is not really anything, and would not otherwise, aside from whether it be a standard or an alternative means of lit funding, they would not be able to defend their claim, would have to settle, enter into a forced license, or shutter their business, or all of the above. So by having this as a viable option, it allows cases that otherwise would have gone unheard to at least reach trial stage.
Yeah, one thing we looked at with regard to patent cases for small inventors, and I don't know if you've considered this, is, typically a funder is looking, at the end of the day, there's a pot of money that's achieved through the litigation and through settlement, and they'll get a piece of it. So for a small company that fends off a troll, what's in it for the funder, and I think it could be equity in the company, it could be part of a royalty license and things of that nature. So that's the kind of stuff we were looking at in order to be able to provide funding in a case where if you win, if the verdict comes in and you win across the board, there's actually no check attached to it.
Yeah, I've just been starting to see that. There was in the New York Times not that long ago, IPNAV, which is a large sort of patent portfolio holder, recently took an equity stake in a new app developer in exchange for financing their legal representation in an ongoing patent troll case. And I think that is really paving the way for other similar entities and funders to sort of take that both as a positive policy step and as a means to benefit in some way as a funder in these cases.
Do you think there's any potential in this space for crowdfunding, either equity or otherwise? And I only say that because I've already been asked through a couple of GoFundMe campaigns to give money to a patent troll defense case.
Yeah, there's one ongoing with the podcast patent is probably one of the bigger ones that has the sort of Indiegogos, the actual where there's no equity. I think hopefully as we see more parity come out of the SEC rules and all that for the new equity crowdfunding, that we hopefully will see that as a means to help and further the funding options for small developers.
So when we first conceived this panel, the vision really was ways of crowdfunding noble plaintiff side and defense side litigation. So the Patent Troll Defense Network immediately came to mind. We had been trying to explore ways of crowdfunding, 1983 civil rights actions. Are any of you aware of anyone out there doing anything like that? If not, why not? Are there ethical, legal, logistical implications? Because it seems like a natural fit, the natural corollary to defending small companies against patent trolls and other big companies makes sense on the defense side, but it seems to be equally viable on the plaintiff side.
So I'm not aware of any crowdfunding in those sorts of cases, which isn't to say it doesn't exist, but I haven't heard of that. There are funds, Sean split the world up into three buckets in terms of litigation funding, and I think the 1983 suit and other similar causes of action would fall more into the personal litigation finance bucket, and what he described as being in that category is probably 98% of that category, which is structured settlements, slip and falls, personal injury, med mal, insurance type cases. But there is a sliver of that sector of the industry that will look at claims that are more expensive to bring, where there could be a larger payoff at the end. So in that way, they look like commercial litigation finance opportunities, but because of the facts or the cause of action or the fact that the counterparty is an individual person and not a company, that's not the sort of case that a commercial funder would typically see. But there are funds out there that would explore those kinds of opportunities.
Yeah, I'm thinking we should create some sort of mutual fund or an index fund, just do-gooders throwing a pile of money into a pool to funnel all the public interest plaintiffs' lawyers out there. That's the vision, I think. So there's a business opportunity out there for a young lawyer.
But are you looking for a return on the investment? Because
you're looking for a way to fund the lawyer. So a lawyer isn't going to take a
But you have the NAACP Legal Defense Fund.
So
you've
on
got
a niche.
You've got other direct action support. That's sort of the question. If you're looking for a return on your investment, which it sounds like the folks that you would tap who would be interested in helping these folks, they're not really looking. Their return on their investment is a more just society.
Well, I'm saying some combination. Why not a 70% return? You'd be willing to take essentially a 70% return on your investment in the aggregate because you know you're doing good in the process.
All the panels fit together. At the end of the day, it's a puzzle.
B Corp litigation.
Don't see it all.
Because then you're not pushing for maybe a dramatic return. You're looking to do a public good, right? That's something perfect B Corp space.
If you make some money back, fine. All right, we're sort of running low on time, but I don't want to discourage participation. I know we've got one more lightning talk from an outsider, not a lawyer, and then I put this last panel last intentionally because I wanted to keep people around for the day. This is going to be a fun one. Not to say that this one isn't excellent.
No, this was clearly the most fun so far, and I'm not competitive about it. It's just a fact. But thank you very much to these three panelists.
Thank you.
Thanks so much, folks. Very often, it takes an outsider with an outsider's perspective to let us know what we're doing right and what we're doing wrong and how we can change. I like to talk about how I helped work with the company that became Vonage. And when we started Vonage, we never hired anyone who came from the world of telecom. Because all they would say is, you can't do it like that. That's not how the phone business works. So what we've got next, Chris, you're not a lawyer, are you? That's what I thought. All right, we've got a non-lawyer's perspective, lessons for the lawyers in a post-Snowden world. So if you don't know Chris Soghoian, it means you probably haven't been following much of the Snowden saga. He's been essentially one of the two primary point people in America for Edward Snowden. And with that, Chris, it's yours.
Thank you. Let's see, is there a way of getting this up? No? It'll work? If I just... Can you guys hear me in the back in the cheap seats? Yeah? Okay. Better? There we go. So thank you all for giving me, I think I have 10 minutes to talk to you. So my name is Chris Soghoian. I'm the principal technologist at the ACLU, the American Civil Liberties Union. I work with a team of lawyers. I'm not a lawyer, but I work with a team of lawyers who do most of our surveillance and Fourth Amendment litigation. I'm a computer scientist that focuses specifically on surveillance, and I spent the previous 6 years studying how law enforcement agencies use internet and telephone companies to surveil their targets. The police don't go to your house anymore and spy on you. They ask Google or Verizon to do it for them. So I've been working on this set of issues for some time, and my community, the community of security researchers, have done a really bad job. We have made tools that are difficult to use. For several decades, there have existed many sophisticated security and privacy tools, but these were tools made by geeks for geeks. In the 90s, there was what we in our community called the crypto wars, a period in which the Department of Justice and people in the administration sought to regulate the export and use of strong cryptographic technology. In essence, as then Louis Freeh, the director of the FBI, he went to Congress and talked about a world in which terrorists and drug dealers and pedophiles could hide from government investigators through the use of email encryption and other sophisticated technology. And so for some period of time, they were seeking to ban or regulate this technology. So Louis Freeh's fears didn't really come about, although there have existed freely available tools for email encryption since the early to mid-90s. I suspect that many of you probably have never sent an encrypted email in your life, or if you have, it was a one-time thing that you tried out and then gave up when you couldn't convince your friends or loved ones to communicate with you. And this largely reflects the fact that encryption software is difficult to use. It's exceptionally difficult to use. There are usability taxes associated with it. The entire concept of public key encryption is something that many people just cannot get their heads around. And so people generally don't use these tools. And of course, what this has meant is that bulk surveillance by the intelligence community and by law enforcement agencies has been far easier than it really should have been. On a typical day, your web browsing activity, your emails, your instant messages, many of them will go over the internet without any form of encryption. And that makes the government's job really easy. I mean, if there is a take-home lesson from the past 9 months' worth of Snowden revelations, it's that the difficult job facing NSA hasn't been collection, but rather how to process the vast amounts of data they've been able to collect. And that's because so much of what we do goes over the internet without any protection. Our telephone calls, our text messages are all unencrypted, just sitting there for governments, for criminals, for competitors to collect. And so it's been really sort of interesting to watch this slowly change. One of the sort of more interesting pieces of the Snowden story is that when Edward decided he was going to go to the press, he tried to reach out to Glenn Greenwald and ask Glenn, he sent Glenn an encrypted email, and Glenn didn't really have a way to open it. He then sent Glenn a YouTube how-to video that Snowden had made himself, teaching Greenwald how to encrypt his emails, how to use PGP. It's still unclear if Glenn watched the whole thing and couldn't figure it out, or if he just didn't care. But eventually Snowden had to go to Laura Poitras, who was a New York-based filmmaker who was slightly more sophisticated and knew how to use encryption software. And it took some convincing by Poitras to get Glenn to download this software and figure out how to use it. And as a technologist, I can tell you, this stuff is a pain in the ass. It is truly unpleasant to use email encryption. And you would have thought that DOJ surveillance of the Associated Press, DOJ investigating people like both Risen and Rosen, the New York Times and Fox reporters respectively, getting their emails, trying to discover their sources, you would have thought that increased investigation and surveillance of journalists by this administration, more than any other administration in history, would have prompted the news media to seek out and use digital security tools, but in fact they didn't do that. But in the last 8 months, I have received more encrypted emails from journalists than I've ever received combined in the previous 10 years that I've been working with journalists. And what's happened is, in the wake of the Snowden revelations, the media, or at least journalists who work on national security and surveillance issues, have really started to get their game. They've started to use email encryption. They've started to encrypt documents stored on their computers. They've started to use encrypted messaging. Inside the ACLU, we are now using digital security tools, which means that when my colleagues are talking to clients, whether they're in Egypt or in Guantanamo Bay, obviously the Gitmo detainees cannot use encrypted communications, but when my lawyers are in Gitmo, they can call back to the central office using encrypted communication tools. And so we've seen a shift where media organizations are slowly starting to embrace these tools. Just today, the Washington Post had a story online revealing that the Post website will be moving to encrypted by default, which will prevent the government or employers or universities from knowing which articles people read. Surely something that is core protected First Amendment activity that the government has no business knowing. We are seeing the media finally starting to embrace this, embracing technologies that allow them to protect their sources, to shield their reporting activities before they are public from the government. But it took a little while. It took some really high-profile stories of mass surveillance, and it took, I think, a little bit of embarrassment for the media to realize just how bad they were. So I think there's something that journalists and lawyers have in common, and that is that typically they both know very little about technology. Of course, many lawyers have a lot more money than journalists. But while the media has slowly, has quickly embraced encryption and other technologies, the legal community has not done the same. In the last few weeks, I was performing an amateur survey of websites of national security lawyers in the Washington, D.C. area, and I could not find a single one with a public encryption key on their website, although every national security reporter I know now proudly has their email encryption key in their Twitter bio and on their respective homepages. the legal community has been really slow to pick this up. Now, I understand email encryption is really difficult to use, but there are other kinds of security tools that are easy to use. And the easiest and most impactful of these is encryption for telephone calls. There are free or very cheap $10 a month apps that you can download onto your smartphone, to your iPad, that you can use as long as the other party has that app. And then you can make calls that are 100% encrypted. That means that if the government wishes to wiretap your attorney-client privileged communications, which they can and will in some cases, that they need to hack into your handset. They need to hack into your iPhone instead of just getting the communications as they go over the wire. There was a story just maybe a month and a half ago revealing that the Australian government had spied on communications between the Indonesian government and their lawyers in Washington, D.C. Of course, the Australians and the Americans and the Brits and the Canadians all share information, and so some of those attorney-client privileged communications made their way into NSA's databases. This revelation by the New York Times led to a very nasty letter from the ABA to the National Security Agency. And while that was good, while I think it's good that the ABA should complain about surveillance of lawyers, I don't really think that's enough. I think that you should never rely on the promises of intelligence agencies that they're not spying on you. And so I really think that the legal community needs to look at itself in the mirror and ask why it has been so slow to employ these technologies. If it takes $10 a month to have all-you-can-eat encrypted voice service, encrypted text messaging service, why are you not using this? Why are you not advertising your encrypted telephone number on your website? If you're charging your client $600 an hour, why does the first hour not include an iPod Touch with this encryption software pre-installed that you FedEx to your client and say, here, let's use this for all future communications? And I think the reason is because you've never really had to, and you've not been punished for not doing so. But I think times are changing, and I think your clients are going to start expecting more. I think we're not quite there to the point that you'll be sued for malpractice for not using these kinds of technologies, but in the same way that 10 years ago no one was installing disk encryption software on their laptops, and today every corporate IT department has this stuff pre-installed on devices that you're issued, I think we're getting there slowly. And so I think the real message from the Snowden revelations for this community is that you need to step up and start embracing these kinds of digital security tools. It's not rocket science, it's very easy, but you need to spend a little bit of money, and ask your IT department for help. Thank you very much.
Thanks, Chris. Time for one. Anyone have one question? One question?
It's more of a statement than a question, but thank you. That's very interesting. As a practicing attorney, in my engagement letter with my clients, I actually address the issue of potential for hacked email and or telephone conversations. I don't know how valid it would be if I were sued, but to at least acknowledge that it is possible, and at this point, since I'm not addressing it technologically, that they should be aware of it and they assent to it.
So I was looking at the website. I think it was Jones Day. I think that was the firm that the Indonesian government retained, but if I got it wrong, I apologize. I was looking at their website, and they do say, if you would like to use encryption, we can make it happen. But I think that's a cop-out. I think you are typically going to be more informed than your clients, and so you need to insist, and you need to make that stuff available. Just to say, oh, you should be aware of the risks, I think that's probably a very lawyerly approach. But come on, buy the software, install it, advertise your keys on your website. Have the encryption, the voice encryption software that we use in our office is called Silent Circle. I have no affiliation with the company, but it's $10 a month. It's easy to use, and frankly, it's sort of cool to have encrypted phone calls. You feel like a secret agent. There's no real downside. Thank you very much again.
Chris, I should tell you, we had a legal hackathon back in February, and one of the winners created a product that was essentially Snapchat for legal documents. So not subject to discovery, disappearing immediately. So, something. The future's there. All right. I know we've gone without a break for a while, but we only have one panel left. What I would like us to do is maybe just stand up and stretch your legs. Are all the panelists here for the last one? Dazza, are you there? Raise your hand. They're all there? Okay. Why don't folks just stand up and stretch your legs so you don't get blood clots? I know this was a very packed day. I think in the future we're not going to have quite so many talks, a little bit more mingling. But in any event, I want to welcome up our last panel, our last unpanel, rather. And I'm going to introduce our moderator first. Our moderator has also been on the Legal Hackers traveling circuit. Where is he? Still on the Legal Hackers traveling circuit. Actually, in fact, I met Daz at our legal hackathon on data privacy back in February, and he told me everything about what he's been doing up at MIT. And I told you all, I was scared to death about what happens when MIT gets a law school.
Be afraid.
It may be happening sooner than we think.
I am.
I think it's probably a good thing for society, maybe a tough road for traditional law schools. So, Daza, I'm going to hand it over to you and engage or rile up your crew as much as you want. This is a very broad cross-section of lawyers/technologists. I would say half of them are probably not really technologists, and half of them are not necessarily functioning as attorneys. But I think between the 5 of them, we've got a pretty good cross-section of what it is to be a lawyer or a technologist, or a lawyer-technologist, or a lawyer working with technologists, or a technologist working with lawyers. It's a very vague animal, new animal that I think we're creating here, and these are the first generation of this new animal, I think. So, Daza, it's yours.
Great, thank you very much. So we're going to be setting up some little technology as we go, but I'll have a slide that will help to facilitate the panel. But this panel is titled, I believe, Lawyer as CTO. And as we've talked about how to bring out the topics from that title in the context of what it would be like to live in a world that's a geek house, functionally, what we realized is the best thing we can do here is model what that world looks like even within our panel. And so there's an agile, of the moment, what Jonathan called an unpanel kind of nature to this, and that's by design. And so this will be somewhat flowing, and we really just encourage people to participate as we go. So the way we're going to do it is the panelists are going to talk a little bit about themselves and their journey, how they went from, in a sense, Bleak House to Geek House, and have emerged as technologists who also continue to use the lens of the law very meaningfully in this information age. And then we'll tune some of the particular topics to the moment. So with that, I want to start with Andrew McLaughlin, if we could. Andrew, could you introduce yourself and talk a little bit about how you escaped Bleak House?
Yeah, so I'm Andrew McLaughlin. I guess I'll do a quick narrative. So law school clerk, law firm in D.C., where I did appellate litigation, randomly ended up in the big internet free speech case of the 90s, which was the Communications Decency Act case, in no small measure because I'd grown up in North Dakota, and when I got to college, I was too poor to make what at the time were expensive long-distance phone calls to be able to keep in touch with people. And so I discovered sort of serendipitously that there was this thing called email on the VAX terminals in the basement, and my college was hooked up to BitNet, and we were able to I was able to keep in touch with like a friend at Reed and another one at Oberlin, and it was like nirvana. Anyway, I got to know how the internet worked at a pretty young age, and then that led me to being a lawyer on this free speech case. Went up to the Supreme Court. It was 2 years of my life, and at the end of which I knew that being a lawyer at a law firm sucked and was not for me, and I wanted to get out. So I kind of transitioned by way of a job up on Capitol Hill for a year working for Henry Waxman, followed a girlfriend up to New York, ended up about 6 months later jobless, single, living in a rat-infested sublet in the East Village with all my crap in Chelsea mini storage. And the pivotal moment of my life.
This is a much more interesting story than mine's going to be. My goodness.
You're just going to have to amp it up, man. No, you're just going to have to outdo me. So anyway, so this pivotal moment of my life happens when I finally really got on track, which was, summer of '98. I'm lying on the floor. I can really remember this moment. It was super hot outside. I was shirtless. In all candor, possibly listening to the Smiths and generally feeling crappy about my life. And I get this phone call, and it was Larry Lessig at Harvard, who had just landed this big grant from the Berkman family to set up a center, and so I gravitated up to Harvard as a fellow. and immediately started working on this thing called the IANA, which was an organization that managed domain names and IP addresses. Within 2 months of me being there, the guy who stood behind the IANA that I was helping as a lawyer, just as a friend lawyer, went into the hospital with a heart attack and died. And so I happened to be around to launch and then run for a couple of years something called ICANN, which is the Internet Corporation for Signed Names and Numbers, very serendipitously, but that's where I went deep on the networks of the internet and got sort of like a PhD level education in these very peculiar little subjects that have never been even remotely useful to me ever since. But if you need me to configure a router, I'm your guy. And that led me to burnout, go back to Harvard, go to Google, where I ran the policy shop for about 6 years, then the White House with Beth. Well, first the transition with Beth, and then the White House with Beth for 2 years, and
He
then
was wearing his shirt.
shirtfully, and then I moved to New York. And since I've been in New York, I've worked on Code for America. I spent a year at Tumblr, and now I'm a partner at something called BetaWorks, which builds tech startups, and I'm CEO of Dig and Instapaper, which are two of the companies we have. And that's how I got to where I am. And I guess my message to everybody is you can and you should escape from being a lawyer. And the best way to do that is to actually get some technical skills and learn how to build stuff and learn how to make things on the internet. Very, very useful. And at the same time, I'm delighted to have a law degree. It comes in handy every day.
Okay, great. And so so part of what we're doing here is we're sort of navigating and wayfinding as we go. So at the end of the story, the narrative, people are popping up naturally and also somewhat by design, topics, that we want to emphasize. And so for you, just tell me if I got this right, Andrew. The topic in a sense would be how to build the skill set to transform from lawyer to technologist, or I didn't quite capture it. Or how would you put it?
It's okay. We can move on. We'll come back to it.
Okay, so it'll be behind you. Beth Novak.
Hi. So I will. It's hard to top that one. I'm going to do it. I'm just going to hack the whole thing and change it. But I will give you a little trajectory on this. So I actually have a background in political science originally, and went. In college, we had to write a senior thesis, and I was looking around for topics that I could do that nobody else knew about. And my grandparents had been chicken farmers in New Jersey, and my parents thought it was an excellent idea that I should stay home in New Jersey and do intensive research from their living room. And I decided that was a terrible idea, and I would rather, in fact, go off to Vienna, Austria, wear black, sit in cafes, drink coffee, and do work on 1920s Vienna and the very fragile time that we tend to think of as Weimar Germany and Weimar Austria. So I developed a fascination with what makes democratic culture work and what makes it fail in the case that it did then, and developed this interest in how do we actually think about fostering a more effective and stronger and more robust democracy. So, coincide with this at the same time, what I'm also doing something also about the unaffordability of phone calls back home. My mother was a travel agent on the side, and so she had a reservation computer, and I had a reservation computer. We set up a fictitious record, and in the annotations and the notes to that record, we would type messages to each other. We did have PCs. I had computers and all of this, but we were using technology, and had actually from very back and early on, there had always been a lot of technology around, so there was always this kind of lurking sort of tech skill set going on in the background. But fast forward a little bit, and this is contemporaneous essentially, or a little before the kind of start of the web, an interest in technology, and for lawyers, including Larry, who is a mutual friend, an interest in how do we avoid regulation, how do we avoid censorship, how do we avoid a lot of the things that people have been talking about today in terms of incursions into our civil liberties that technology makes possible. Coming from this other angle, this European angle and interest and this historical angle, I early on developed a fascination with how do we actually use technology proactively to do things to make our democracy stronger, to make our society healthier, to make it better. Around about this time, I started a software company with a political philosopher. That is, never do that. I bet you do not have any startups with political philosophers.
Yet?
Yeah, don't do that. Not a good investment. We were interested in how we could use the web to foster more healthy democratic deliberation, so we started a software company called Unchat. And as part of that, I sat with and was educated by the geeks and technologists. We sat with each other. In the world in which lawyers sat in offices behind closed doors, geeks sat in open office spaces, as we're also familiar with now. And I developed a high level of technical literacy, or actually a mediocre level of technical literacy that was very high for a lawyer. In thinking about these questions, that's burgeoned for me into a career path that has taken me, I have been in private practice, I have been in the government, I have been in academia for many years, and now I'm running a thing called the Governance Lab at NYU, where we are both a think tank and a do tank, focusing on these questions of how to use new technology to help us govern better. So it has been one very long trajectory from the cafe houses of Vienna to Brooklyn.
So,
Perfect. Please.
My background is also, I have a degree in political sciences as well. I ended up starting to work for Al Gore in 1997 and up until his campaign where I was his IT director. I did not invent the internet with him, although I helped him to name it. So you know, it was a Saturday night with too many Miller Lights, and that's what came out. But as I worked as his IT director, which to me is a very interesting thing to think about retrospectively. The challenges that I faced in 2000 are really aren't even challenges anymore. It's I think quite astonishing the distance that we've traveled since then, which I'm happy to talk about. When after we lost, I ended up shirtless in my apartment, wallowing in misery.
So did we all.
Yeah, we always end up shirtless, I guess. I also, for some reason, ended up eating a lot of Egg McMuffins for a period of time, but that's it's unrelated to my shirtlessness, but that's
luxury.
Yeah, exactly.
Luxury.
Exactly. I guess it's one of the signs of depression is your Egg McMuffin consumption. And for me, law school was plan B. So law school was a second career, and I went to law school. I started in 2001, and when I graduated, I wanted to be a lawyer. I wanted to litigate, and I went to a large New York law firm as a litigator. And the one thing I knew about discovery and the one thing I knew about technology is that I had no desire and no interest to do any document review. Right now, I run our document review efforts at a different firm, so you can tell how successful I was at in that regard. But as I was practicing, I was junior, but I was probably older in years than most of my peers, and I recognized that as a first or second year associate, I'm not going to be taking depositions. I'm not going to be appearing in court. How can I, though, get to a point where I will be that person? And for me, it became apparent that the facts are at the basis of what litigators do, and unfortunately, the facts are contained in the document. So if I was a better document reviewer, I would have that much more opportunity. And I would participate in calls about what had then become e-discovery. Before it was just discovery, but for some reason they decided to throw an E on it. And I was on calls, and the partners would hang up the phone. It was about technology, and one would look at the other and say, I have no idea what they were just talking about. And I said, I got it. And they said, how do you know? You're a first year, you know nothing. And in retrospect, it was clear that they had brought me in just to throw me a bone, and they're not going to charge for my time and all of these other things. And I said, because I did this. I know what a PST is. I know what a DOC is. I know what all of these things are. It's not, and they said, great, it's yours. Take it. And one thing led to another, and I became more and more expert in e-discovery and ways to improve document review. And after a number of sort of transitions to different firms, I'm now at a different large law firm, and I run our e-discovery efforts, our e-discovery strategy. How can we use technology better to improve efficiency, to focus on value for our clients, and enable us as lawyers to get at what we really ought to be getting at, and what do we value, and how do we target and get there. So that was my path.
Do you keep a caseload?
No. So I'm a lawyer. I'm on the administrative side of the law firm. I haven't billed an hour in almost 7 years, which is terrific.
Okay, well, I'm the least interesting person at the table, the one with the weakest bio, but probably the most accidental technologist at the table here. I'm actually not really a technologist. I play one on TV. My life started as a choice between library school and law school. I'm a third-generation lawyer, so my dad said, well, a JD probably won't hurt you. So I ended up going to law school. He said, you can always go to library school. So I went to law school and actually found that I thought I wanted to do that. I thought I could be a pretty decent litigator. But while I was in law school, I worked as a pretrial release officer in the lockup. So I typically worked the 7 at night till 3 in the morning shift. And got to know a lot about actually the information systems that the jail used to manage the prisoners within the lockup and within the jail system. So then I got an internship in the prosecutor's office. And this was step one in becoming a technologist. So we're being given a tour of the prosecutor's office. And one of the deputies said, oh, there's one of those things. This was a dumb terminal, right? So, and what I found out later is we had an AMDAL, which was really rogue for that point in time. Since most everybody had IBM, apparently someone had gotten very upset with IBM. Anyway, there was this dumb terminal. And she said, I wish you could tell me if one of my defendants was in jail. And I said, well, it can. And she said, well, how? And I sat down, and I did the magic key thing. And I said, what's his name? And she told me the name, and I said, yeah, he's in 4C, or wherever he was located. And she said, how did you do that? And I said, well, there's this little thing. You just type in this, and you do that. So then the next thing that happened was my first assignment was to the chief trial deputy, and he had a big capital case. And we had about 7 or 8 banker's boxes worth of material to go through. And while I was working there, they had secretaries, but it was like a 10-to-1 ratio, and I was the lowest person on the totem pole. Never going to see a secretary, but as a practical matter, I could type better than most of the secretaries anyway. And so they had a mainframe word processing program. It was much like HTML. You had to embed the code to make a paragraph or to make a bold or whatever. But what most people didn't understand was it also had an indexing program as part of it. And so I took the materials from the banker's boxes and I put them into a document, and then I indexed them a couple of different ways. And then Monday morning showed up with the list. And suddenly, the next thing I know, I'm sitting on panels and things for the prosecutor as the computer guy, because I had discovered this wonderful thing that could be done with all these computers. And so at that point, the guy I worked for, Steve Goldsmith, who actually some of you might know that name, he was deputy mayor here for a period of time. He was my first boss. He was very interested in building one of the first combined civil criminal justice systems in the United States. And at that point, we had hired Coopers and Lybrand to come in, and this is how long ago that was, to come in and build something. And after about $1 million, they had vaporware. So I was made director of the agency that then oversaw the implementation of that first system. So all this time I'm still actually during that time I transitioned from deputy prosecutor to head of pretrial services to court administrator. So I basically was everything within the criminal justice system except the probation officer, because we were allowed to sit as judges in Indiana. So I did that half the time. So I had a really interesting opportunity to begin to understand sort of the basics of what it takes to build a large information system. And when the guy from Coopers and Lybrand showed me a data flow diagram, I thought I had died and gone to heaven, because I really realized that all the stuff I kind of liked about library stuff was really very much information science and information processing, basically. So from there, I had a number of different stops and starts as trying to be a lawyer. I worked on the East Coast for a while in Philadelphia for Pepper Hamilton Sheets, and then went to Illinois and worked for a 6-person firm. Did estate planning, general litigation, and then I finally ended up. In '95, I decided, okay, I've run away from being a lawyer. I'm going to give it 5 years, and if I really don't like it, then I'm going to library school. So that was roughly February of '95, and by May, I was going to library school because I just wasn't going to do that. But I still needed to work a little while to get myself sort of in order to go back to school. And so the last thing I did actually was I had a solo practice doing ad valorem taxation, property tax work in the state of Illinois. And sadly, I was smart enough to recognize that assessors' records were all public information, but not smart enough to make Zillow before Zillow got made. So I've always thought about those kind of information things. Then after library school, I went to work in the private sector for a consulting firm that did intellectual property stuff. And now I've ended up in the academy. And I'm in the academy because we were eventually bought by Charles River Associates, a Boston-based firm that's publicly traded. And there's a day, and I'd have you bring up Google Finance. I could show you this day in 2008 when our company lost 50% of its market cap. And that was the day I decided I probably should go back to school. So I decided to go become academic law librarian. So I went to the University of Illinois. I'm on the hunt to be actually the director of a law library in an academic situation. But right now, I'm at the University of Missouri, Kansas City with Professor Lupino, where I'm the associate law library director, but I'm also director of IT for the law school, which gives me a really interesting opportunity to do a couple of things. One, to rethink and reinvent, I hope, on some level, what law librarians are doing now in this particular time in the academy. But second, to also stake out a kind of a claim for the kinds of things that I think we need to be teaching our students in order for them to become technologists. As I was telling my fellow panel members here earlier, technology is really a skill set. You know, legal, and the reason I'm claiming law librarians as being the natural sort of folks to do this is because if you look at what's happening in legal research, the legal research platform, so Westlaw, Lexis, Bloomberg Law, none of these things are standalone products anymore. In fact, Thomson Reuters has explicitly said they are out of the content business. They're about building legal solutions. They are building practice platforms. They are combining all their tools in a way that these are things that you have to understand how to use in order to practice effectively. So it's not just a matter of it's a matter of knowing technology, but it's a matter of knowing how this technology works. And as I was telling these folks earlier, you know, sort of following the Casey Flaherty Kia model, which you may have heard of, Casey Flaherty's general counsel for Kia, and he won't hire a firm without them taking a technology test to prove that they can use their material, or they can use Word, for example, efficiently, which is actually pretty low tech. But on the other hand, it's an example of what we could be teaching and should be teaching in a much broader and I think more effective way. So anyway, that's my spiel. Sorry, not nearly as interesting as those guys. But the end of it is I get to say everything I learned in jail, which doesn't sound exactly right.
Cute. Perfect. And so what we just did is like an unconference, but it's an unpanel. So we all just basically bubbled up the topics for the panel. And what I got from this basically was, Michael, you're talking about the need to teach in the academy here in law school. The information science is the phrase you use, skill sets necessary for people to practice law, right, of the future, and also to transition from a Bleak house to Geek house. I heard you talk a lot, Steve, about the practice of law and litigation and the transformation with discovery. So that's a data science, frankly. And you raised the question, what do we need to be learning in law school to practice that data science for that practice area? And for you, Beth, I heard for those that are practicing law or ascending beyond the law and working in government, how to use technology to govern better. And there's a direct, unbroken chain there from the other panelists. And then finally, first and last, Andrew talked about how to, what I got from it, still unvalidated by you, but what I got from it was how to, in effect, transform from lawyer to technologist or lawyer to geek. How to do it. Like, here's what you do. That, to me, sounds like a good panel. Let's do it. Discuss. And can we start with you, Andrew? Like, how do you do it? How do you, in fact, make the leap?
Well, so I said this sort of glibly earlier, but I would echo, what Michael said in maybe a somewhat different way, which is to say, within it's not really an echo, is it? I would echo it. I would recast it. That a lot of what you learn in law school is kind of like what books to look in to find stuff. At least I felt like that was a big part of my law school education. It's like, you want to find a statute, here's how you find a statute. You want to find case law interpreting that statute, here's how you find that. You want to find articles criticizing these cases or presenting an alternate view, here's how you find. A lot of it is just sort of like finding the right stuff at the right moment. And that kind of like systemic approach to the law as a body of information that needs to be navigated and cohered and and so forth is it's really not all that different from what I spend my time doing now when we build stuff. So when we build a new thing at BetaWorks, it's basically like, all right, you're going to have some profile information over here, some RSS feeds coming in over there. You're going to structure it in the following way. A lot of it is just basically like broad scale information structures, and then presentation and navigation. Okay, so that's the good news. The good news is that there's like common threads through all these things that unite it. The bad news, though, is that if you want to get out of the track of being a lawyer, and in fact, if you even want to get yourself into a position where you can be a sort of a first-rate general counsel at a startup or a technology company or something like that, you really are well advised to spend some time, spend some of your weekends, evenings, free time, whenever you have to do it, actually learning how to build stuff. Like your job gets a ton better if you understand the stack and the technologies that comprise the stack, and you understand how to second guess and assess what you're looking at. Is it good? Is it bad? Is it likely to work or not? Should it be done in a different way? Like all of those are the kinds of questions that any lawyer at a startup will spend their time doing. It's not just a matter of figuring out the next round of financing, lining up your D&O insurance, all these kind of like corporate lawyer responsibilities. A good general counsel is constantly assessing how to help get the company where it needs to go, and how to get the product to kind of live and thrive in the environment that we live in. A lot of that has to do with kind of the structure of the market, the nature of the technology itself, and what stands between the two. So yeah, I mean, what I advise people to do, all the time is, take a class in building, a mobile app, let's say, or basic website architecture and design, and learn how to code. There's so many great courses and tools out there online, and it's so much less difficult than you think it is to go from a command line to a fully functional like interactive game or web page or something like that. It really is not that hard. You can do it in a couple of weeks, a few hours, a weekend, and you should. It's a little bit like learning how to fix a car if you're a driver. Like you feel better about yourself, and you're more empowered, and you feel less likely to be snowed out in the world of, let's say, New York City startups, if you actually can talk the talk.
So I'm just thinking, as you're talking, I'm just thinking a little bit about, one of the things that's been on people's mind a lot, which is the healthcare.gov fiasco, one in which, the people at the forefront leading an effort like that are all trained as lawyers, and they're all trained in a particular kind of way of doing business, right? So they know about going to the Hill and negotiating for a piece of legislation. They know about the sociology of legal practice. They're really great masters in it. And to them, technology is an afterthought. It's a way to get, done after the fact, but all the investment, all the energy is in that wrangling about drafting the bill. And of course, the realization that has been brought home by this, by what happened earlier this year and late in the previous year, is that technology can't be treated as an afterthought, because otherwise you become, you fail to even have technology at the table. You fail to be thinking about how to implement the thing that you've legislated, and you're not in a position to push back against the technologists who say it needs to be X if you think that's not your job to know what that is. So the riffing, I wholeheartedly agree with Andrew, and I think that law school, when taken as a given today, we tend to either see it or be so focused on memorizing the stuff that, you open up the head, you pour in a bunch of content. We're supposed to learn a bunch of seminal cases, memorize a bunch of, Penoyer, Renef, whatever, and everything that comes from it. It's either that, or it's about that mastery of the sociology of a certain set of institutions. How do I navigate the legislative process? How do I navigate the regulatory process? How do I navigate the judicial process? It's about learning how to be a member of the club. When what law school is about, what being a lawyer is fundamentally about, is about being a problem solver. And in the 21st century, problem solvers have to have an expanded set of tools in their toolkit, of which technology is obviously one. So if you are a lawyer, I don't think it's about transitioning from being a lawyer to being something else. I think to be a good lawyer, you have to know something about technology, because otherwise you can't have the conversation about healthcare.gov if you think it's only your job to know about how to draft the legislation. Unless you realize that what you're trying to do is to solve a problem, namely to reduce the healthcare cost curve and deliver better services to people, you've got to understand the full range you have to understand the situation and be able to manipulate all of these processes, the drafting of legislation, the crafting of regulations, the creating of a website, all become part of your bailiwick as a general problem solver and as part of the conversation. So I think it's not about fleeing from what we do, it's about a recasting of the recasting, allowing us to think differently about what is part of and what is included in that law school education.
I agree, and I think that to frame it as attorneys as problem solvers, I think is exactly right. And in order to understand how we solve problems, I always think about value, and I'll use an example. We have a client who is in a large litigation, a technology client, someone most people have heard of, and we were talking about collection, and their data is all over the place, and we had a conversation with them saying, you know, you're paying for this. This is going to cost you more money because of the way in which you store your data. And they said, listen, we're not in the business of defending lawsuits. We're in the business of inventing stuff. And those guys and gals over there invent stuff. And if they want to store their data that way, that's their prerogative because they need to invent stuff. So the lawyers aren't going to tell them how to think. And because the problems we're solving have to be tied into what they value. And for technology, in the context of getting towards that end, we have certain things containing us. So, for example, in project management, there's this concept of the iron triangle, right? There's the cost of doing something, there's the speed of doing something, and there's a quality. And you can have something fast and good, but you can't have it cheap. You get to choose two, right? You can have high quality, low cost, but then it impacts speed. So that's iron triangle. There's another thing in the military, this concept of a force multiplier. And that talks about that a certain number of soldiers can do X amount of work, but a force multiplier is going to enhance them. So 10 soldiers and a helicopter is better than just 10 soldiers. A helicopter is a force multiplier. 10 soldiers and a drone, 10 soldiers and a tank, all of those things are force multipliers, right? And if we think about the iron triangle, that we can only have two of the three factors, to me, technology is a force multiplier. How can we, as attorneys, bring more value based upon these limitations, these constraints inherent in what we're doing? And using technology, particularly in the area of discovery, can enhance our value. They are our force multiplier for us, and it enables us to do more with less at a lower cost and higher value. And that, to me, is what technology enables attorneys to do.
And sort of following up with the Academy and what the Academy needs to do, I'm sure most of you in the room are familiar with Dan Katz and his Reinvent Law stuff. And Jonathan had asked earlier whether or not Dan had written this tongue-in-cheek article about the MIT School of Law. It's actually not tongue-in-cheek. That's one of his most serious presentations. Because the idea is that there's a whole set of things that someone would go to MIT to learn that they are not getting in law school and that MIT would focus on. And I think that's right, but I think there's also this kind of large continuum. And the way I kind of frame it is with e-discovery. So e-discovery is this interesting point in the law right now where lots of law schools aren't teaching it or not teaching it particularly well, trying to figure out how to teach it. Lawyers are struggling with it, judges are struggling with it, but what they're struggling with is really a continuum. So on this end of it, you have, what is autonomy? How does autonomy work? What is the technology to get the thing? And on this end, it's how do I craft the right order to get in front of the judge so I can get this part of what I need done? Well, this end can be taught in and of itself and can be a thing unto itself, but honestly, it's the whole spectrum, and they all have to be brought together in a way that the competent lawyer, the comment 8, 1.1, rule 1.1, comment 8 competent lawyer gets that spectrum. They don't necessarily have to understand the guts of autonomy or how it works, but they need to at least understand what precision and recall is. Because actually the truth of the matter is they're doing it when they use Westlaw and Lexis or Bloomberg, they just don't know they're doing it. So I just think the Academy has a really long way to go at the moment, but it's even more than that. The conference, Professor Lupino and I were at a conference yesterday for solo and small firm incubators and residency programs, sort of post law school things. But there was a talk about the longitudinal law school, the idea that you begin to look for people in the admissions process to bring into the law school so that you seed them, or you have people who are seeded before they even get to law school. So in this case, it was people who were committed to the idea of social justice and public interest. In this other case, it would be STEM students. We need to do more for recruiting science folks, people who are technology, engineering, math, to come into law school. The Bill Henderson model, the model that he talks about is, having folks who become domain experts so that you become more versatile that way. You can end up working for an e-discovery vendor or someone, or you now have the skill set to be able to advise clients appropriately. But the academy has to be in a position to be able to teach those things in an effective way.
So, excellent. So now that we've had that panel, let's try something different. So why not apply the insights that we just heard and spoke to a problem? One of the things we brainstormed getting ready for the panel was some example scenarios of that come up in everyone's practice, whether you're CTO, lawyer, or otherwise, and talk through how people might approach that. So the top three, I think the most appropriate one is there's a high priority launch of a web service, because since you brought up Obamacare, you called this one to my attention, but also it's a nice scenario. It happens all the time. That web service could be a government agency, it could be a private company, it could be something internal to employees, but it's high priority and you're launching a web service. There's technology involved. There are legal implications frequently depending on what that service is, if it's heavily regulated in some way, for example, or if it's part of a supply chain contract with complex provisions that must be modeled. So generally, I'm curious, I can say just one word, because people have referenced MIT like multiple times, Jonathan and others. Something we do a lot there, and the reason one of the key reasons I was drawn to it is we so-called hack things. We hack them up, and by that I don't mean unauthorized access to a system. I mean agile, rapid prototyping design method that favors not having things perfect prior to start, but rather an iterative approach. So hackathons are well exemplified, or putting something together that's rough as a rapid prototype is a good example of that technique, and that goes across really almost all the departments. It's interesting to see how it plays out in the human studies as well as the hard sciences. I don't know what you're thinking the right way to do this is, but can you speak a little bit to a scenario? And I know you've been through this many times. It's really your career. It's a high priority launch of something on the web, an app, a service, a site. How would you exemplify what you just described, Andrew? Like, so you've got people that are either learning or they're showing it.
So the typical, the typical. There are a couple of axes of tension that arise in these scenarios. One that you often see, it's particularly true in government, it's, maybe less so in startup land, but is the lawyers basically just act as like a Maginot line of defense against launch. They're just armed and ready and isolating risk after risk after risk and all of the things that are going to go wrong and trying to document everything. And that was, it was fascinating to see the healthcare.gov sort of debacle from afar because, Beth and I are probably two of the least surprised people on the planet when the whole thing melted down because the government is sort of like purged itself of technical competence over the years. It is, outsourced to contractors, kind of the provision of every form of technical service. And part of that is because government can't pay very well, technical skills are very much in demand, and virtually anybody of any level of competence in the government can go flip over to being a contractor and make twice the money. And so they do. So that's part of the problem. The civil service structure makes it very difficult to feel like you're going to have a flexible and interesting career as a technologist inside government, with a few exceptions. There's some agencies like NASA or the NSA, which, if you're into that kind of thing, have spectacular vistas for professional growth. But anyway, for most government agencies, it's just not there. And so So anyway, what you end up with is this kind of like lawyer-administered, lawyer-driven contractor world where it's all driven by the things that can go wrong. The interesting thing about healthcare.gov was that it had a deadline by which it had to go live, unusually, because usually these things just kind of like stretch on for decades. But you saw what happened, which is that it launched totally pre-baked and riddled with bugs, errors, and terrible architecture. So anyway, so one thing that goes on all the time is that, and a good CTO lawyer or lawyer CTO is somebody who understands how to orient the legal thinking around what Beth said, which is problem solving rather than risk flagging. Most lawyers think their job is control risk, control risk, control risks, and use instruments like contracts and indemnities and exchanges of letters and all sorts of other things to minimize risk, to identify it, to call it out, and then to smother it. But that is totally wrong in the technology world. You cannot be that lawyer. And I have to say, when I was at Google, I saw what I think is probably the best legal department of any technology firm ever. Incredibly deep talent, extraordinarily competent lawyers, from very junior lawyers to senior lawyers, up and down the stack. And the ethos there was basically like nobody can ever say no to anything. Like Larry Page says that we're going to like build a nuclear reactor, under the Google office in New York. Your job is not to say that's insane. Well, maybe you can say that's insane, but like, okay, let's go do it. That's your job. And, sometimes that gets a company like Google into trouble, but the ethos was solve the problem. And generally they'll figure out that it's a ridiculously terrible idea on their own from the engineering perspective. But so anyway, that's like one part of the lawyer's role in the process.
Yeah. Can we have a microphone? Hey.
Google Nest was working beautifully, and no users were having any reported issues, and they're withdrawing Nest Protect smoke alarm because there may be a possibility, if a set of events were to occur, that the smoke alarm would turn itself off. And so Google Nest is being pulled, which I think is shocking.
Did not know. Mm-hmm.
Okay. You were there pre-IPO?
There you go.
I was, yeah. You might have changed it as a publicly traded company. You're saying it might be.
And actually the question I asked was, let's talk about examples of times when it's working, so that we can get our minds around what is this new model of when lawyers act in a way that's conversant with the technology sufficiently so that they could be posed a question, how to, not why not. How do we engineer? How do we design? How do we creatively charrette a solution that operates at the business, legal, and technical dimensions elegantly?
Well, just to add one other thought, I'm sorry I'm like blathering on so much, but one other thought, which is that the area in consumer internet services and enterprise internet services where this comes up all the time and where the lawyers have the most important role and where they can screw things up the most or help out is around privacy. So privacy is the management of information. It's fundamentally about doing right by your users, and secondarily, it's about legal liability. And so lawyers interact with technologists around privacy issues probably more than anything else and set the parameters for what kind of data can you carry, what do you have to tell your users, what kind of consent do you have to get. And this is one of those areas, like just to be very specific, where the lawyer can either like solve the problem and figure it out and set real parameters, set boundary conditions within which the engineers have to operate, or they can basically like blow up, your ability to actually launch the service. And a good privacy lawyer is one that is very much a problem solver, a principled problem solver, a user-focused problem solver, but a problem solver.
Principled problem solver. Tweet at the ready. Beth, how do we do this? So you got a new launch. I know you've been through this too when you were CTO. You did a lot of open gov, and since then you've done launches in your foundation now. When it's hitting right and the lawyers and the technologists and frankly the business team are operating well together, what does it look like?
Well, as is being hinted at by everybody explicitly, is that first of all, it's about having the lawyers and technologists there from the get-go as part of the design team for any launch. And whether the lawyer and the technologist are one and the same or are two different people will depend on the people and the organization, etc. But I think when it's done well and when it's done right, the lawyers they're part of the same team. If you're starting from that common point of saying our goal is to get this done, whereas in government, what we've seen far too often is that, as a friend of mine refers to them, government is the land of the no machines. And it's your equivalent of the Maginot Line, which is a better phraseology, but the lawyers are often there just to say no, to serve as the babysitters, to serve as, and it's with great conviction that people will tell you, I've been in rooms where people will say, I am here to, babysit the politicians. I'm here to babysit, in other words, either the technologists or, more dangerous, are the politicians, the people who want to do crazy stuff, and they're there to safeguard the public interest, the taxpayer dollar, etc., by doing things exactly the way that we've always done them. So the notion that doing something that might be perceived in some way as different and therefore experimental is a bad thing, I think is changing. I think is going to change, because when you've had people who work in government, like an Andrew McLaughlin, and people recognize the value, the people that worked around him and with him recognize the value of that, it creates a demand for this new generation, this new type of lawyer who is the yes machine rather than the no machine, and who is the person who can be at the table as part of the conversation about how to have the web service launch. I'm just thinking about it really. I just want to cite this example since you want a specific, and it's not a project that I've designed or built, but one that I've admired from the side, is work done by the Annie E. Casey Foundation in Indiana, in fact, as well as in their regional child service offices that they operate. Their goal is to use technology to help improve the plight of abused and neglected children. And what they've done is they've come in and take the very hard task of trying to re-engineer a creaky, old, antiquated legacy systems that are used in child welfare offices around the country. And starting with a pilot they're doing in Indiana, what they're essentially doing is rolling out what they call Casebook, sort of like Facebook, for children, and essentially you put the child at the center, and all the different providers and social workers and doctors interact with one page. So it's an information management system so that information doesn't get lost, doesn't fall through the cracks, and so that there's a hopefully better conversation. They're seeing tremendous results already in the first year. But it's a project where they sit in an open space with technologists, with lawyers, with domain experts who work on child safety and child care and child services, in a team together, working on developing a solution that is radical and revolutionary on the one hand, but at the same time interfaces with, that works with, that connects to traditional institutions and cultures, so that the state of Indiana can say, we will adopt the system and we'll try it and we'll do it. So I think the temptation to say, let's throw the law overboard and just go the kind of libertarian, geek, Silicon Valley route is very tempting to say we can do everything with a startup. But in fact, institutions have an important role to play, governing institutions have a strong role to play, or other kinds of institutions. And so we need to be able to reconnect those legacy systems, whether they're technological or policy and legal, to the new way of doing things. And for that, you need people who know what Pinoy or VNF is.
They must be in the broader Project Penumbra. Okay, you're on.
So I think what we have to do as attorneys is, again, understand the business that we're working for. So if we're a GC, we have to understand what our employer is in the business of doing, and enhancing that and helping to support it and not create all of these roadblocks. I think this conversation about Nest is interesting. I haven't heard it before, and I don't know anything about it, but based on what you said, if they stop selling Nest because it might not work when there's a fire, think about GM and what they're going through now. So as the attorney, we have to sit down with them and discuss their business. You're in the business of selling these Nest products. You're in the business of selling these cars. If we don't fix this issue, what's going to happen? And let's help you solve this problem. This is your exposure. This is your risk. This is the cost. You're in the business of doing this thing. Are we preventing you as the attorney from doing the thing that we're in the business of? Or are we being your early warning sign saying, I know you're in the business of selling these cars, but this is to the point, like, people apparently are dying, and the cost might or might not outweigh the cost of fixing it, might or might not outweigh the cost of not fixing it, but there's a larger exposure here. So we're not trying to prevent you from making cars, but we do have to talk about this issue here. So if there were 12 houses that burned down and the smoke detectors never went off because of Nest, then they're in the exact same position as GM was. And the question that the head of Google is going to ask is, well, why the heck didn't you do it? Why didn't you recall it? Why didn't you fix it? And what we have to do as the attorneys is help the business people make the business decisions. And we have to give them that advice and counsel to facilitate those decisions. And sometimes even with the best of intentions, people will make bad decisions. So perhaps GM said, you know what, there is this problem, it definitely exists, but it costs $100 million to fix it, and if 10 people die, figure out we'll settle out at a total of 80 million, and 80 million is less than 100 million, and we're in the business of making money. We had that panel earlier about the corporate responsibility to shareholders, and maybe that's the way that calculus is done.
So our final panelist, Michael, has kindly deferred some time to stimulate what we've been saying with even a more direct example. So you all won't be able to see it here in the panel, but tell me if this is an example of what you have in mind, or if it isn't, and if and why. So this is a project I've done. First of all, I happen to agree with all the panelists, and here's an example of a way I had attempted to do what you're saying. This was a project that was in a so-called identity federation. It's basically single sign-on, using SAML 2 in that case for the insurance industry. And what I realized is that there's mostly technology. There's a lot of legal issues here. This is brokers, agents logging into everything from Progressive Insurance to the Hartford and many different industry large carriers to do health, life insurance, auto insurance, many different types, and tangled web of many different systems, many different passwords. They can unify it with technology. Yeah, they can, but it's somewhat complex to integrate all the systems, to make sure all those contracts reflect that we know who has the risk. And the major thing, of course, that I want to reflect that Steve's been saying again and again is the business case, the business drivers, the business owners of the system. It starts and ends with them. So the way I reflected in this project was they hired me to basically create the rule set and, in a sense, the architecture. My title was architect in that case, and the title was business, legal, technical architect. So what I did was convened across the industry, send your business people, number one, to make sure we understand what we're doing and why, the scope. And so the big and the small players and players from across the industry sent CEO, or more often COO or CFO, or people that work near them to represent them at the meeting, to describe and agree on what is the purpose of this, what is the business driver, what's the business here, what are the imperatives and the priorities. Because lawyers we shouldn't tell them that, technology should not tell the business people that. We have to hear that and then iterate. Then there's a second committee, send me your lawyers. And by having the larger and smaller firms and some firms from across the industry types, broker agents as well as carriers, send the lawyers, enough of them in my judgment, to get traction on what their issues were and to iterate those provisions of an integrated architecture, the roles and responsibilities, the relationships, how it fits with the existing contracts, when the risk of loss shifts, basic stuff, that we could come up with something that would have some traction. And then finally the technologists, which was the biggest committee, and that was the fun, in some ways the most interesting committee, and they came up with the architecture, and it was very cool. The idea then was to make, by not having a lawyer be at the end of the process on a margin of a line with arms locked, thou shalt not pass, rather smoke them out right in the beginning and have them come to the meetings. But you can't have the lawyers at the meetings because that's a culture clash. But there's a way to integrate them in so they can talk. And then basically in this case, I just literally cycled it. So when the meeting was done, we had a draft of a section, like section 1's business stuff, section 2's legal stuff, section 3's technical stuff, and then we'd circulate the draft to the other two committees, get feedback, and then people were ready to have a conversation. And then at the end of that process, we had a unified glossary. At the beginning of the process, we had chaos. Even within the teams, people use different words. Certainly between business, legal, and technical, there's different words talking past one another. By doing this type of process of coming up with different methods, and this is just one, I found it was possible to start to get at integrating better. And there were enough lawyers and enough technologists and enough business people that wanted to work together to solve an important industry-wide problem that it was a reasonable context for it. In smaller and smaller teams, you can't have committees. You don't want committees. But there's got to be some way for people to talk. So what you see here, this is the result, and we put under Creative Commons, God bless them. It starts with the scope, like what are we doing? And then there's just a bunch of business, legal, and technical terms. You can see it yourself. It's idfederation.org. So anyway, that is an example. Let me ask you, if there's a big launch for a project, and it requires an architecture, and let's say it's going to require some new terms and conditions for whoever you're dealing with, it may require some new technology, or at least a more explicit specification of the interfaces and maybe the standards or configurations. It'll require some business processes, some business statement. It require probably, at least some statement of why we're doing it. Who's the profit? What is the goal of the project? What have you? Is the business drivers there? Have you ever seen, how about this process of having an integrated architecture with some business, legal, and technical sections literally comprising one unified architecture to cause people to be in the same team but pulling the same direction? Discuss. Is that an example of what you're thinking? You're like, oh my God, not that. Like you missed it because. Or I have a better idea, and it's this.
I mean, I think it just makes logical sense because depending upon what the business is, it gives the attorney the opportunity earlier on to address the problems. And there are certain problems that only attorneys can see. I mean, if I was starting some sort of gun making company and I said, all right, instead of shipping the guns, we're just going to have people take them and fly them places, everyone's going to say, well, you're crazy, you can't take guns on a plane, right? And that's easy.
It's worse than snakes on a plane.
Right, yeah, it's worse than snakes on a plane. That's an easy issue to solve. That is a legal challenge, and if everyone thought it was a great idea, ultimately the lawyer is gonna kill it, right? There are other problems that only the lawyer can see. And if you just say, if you're sitting down at the kickoff meeting of the healthcare.gov thing, and the lawyer's there and say, by the way, everything needs to be encrypted, and then they sit back. Now, that's not doing anything other than saying, just so you know, there's this legal risk out there that's easily addressable up front if you think about it in this context. Yeah. And I think that's what you're sort of bubbling up is it's not as much of an issue if you can address it early on.
So to me, it sounds like you're exploding out the concept of what the legal hacker movement is supposed to be about. We do a weekend legal hackathon because we felt like wallflowers at the hackathon. Yeah. How do lawyers better integrate themselves and adopt that hacker spirit? Yeah. So we brought them to us so that we could sort of learn and actually play a pivotal role. But it sounds like you're taking a weekend-long enterprise and turning it into a bona fide venture, a process for real ventures outside the confines of a weekend hack.
Yeah, that would be where this would end up. I think this method, this method seems to work pretty well with humongous projects that go many months. This one went more than a year, and you have a long time to get people ready for it. Ultimately, if people, if the academy did a better job and people were ready to talk to one another, and we're ready to have an agile sprint session, you could do a lot of this very quickly indeed. And I think it's better done, most of it, quickly in like a hackathon. And actually, sometimes, we do a few things at MIT. We do computational social science studies. That's in the lab that I'm at, Sandy Pentland's lab. Very frequently, when we're getting ready to start one of those studies and we're architecting it, it's mostly technical. How do you get the data from the Android phones? How do we get them in the hands of the students or the participants? There's a legal part, it's informed consent, some sort of IRB, and there's a user term thing they click on. And it's mostly a business driver, like what is the research we're trying to do in this case, and how is it better? How do we get the right data sets? These people that work with Sandy are agile by birth, apparently, and we cover a ton of ground in like a couple of few hangouts. But then what you want is a slow boil to iterate it, circulate it, socialize it with organizations, get feedback, and then come back and maybe do another sprint. So I think there's a role for these hackathons. It's invaluable as a model, but then it probably needs to serve as like punctuation of a project within a larger envelope that ensures that the right questions are asked and addressed. Some adult supervision, which is why I always like to start and end with the business people.
You missed our the demos. We did a greatest hits of our post-hackathon activities. So a lot of the projects that were incubated at the hackathons demoed today, several months later.
Yeah, but my only like sort of wish is that like enough of your students can get enough years of experience so that we can start hiring them. Like because what you're teaching is exactly the right stuff. I mean, it's an attitudinal thing as much as anything else. But I have great great hopes that as you build the center of gravity, I have to quit using these screwy metaphors today. So you build like a growing blob of legal hackers that will come to characterize.
They launched Legal Hackers Detroit this week. Legal Hackers DC ran an event a couple days ago. We had Seattle. Seattle's been tweeting all day.
Yeah.
I think now we're launching 16 chapters in Europe in the next few months.
So good. It's why I'm here, actually. On a personal note, I wouldn't be here if it wasn't for, the Legal Hackers organization that was an outflow of your Bleak clinic and Phil Weiss, I think, who's an alumni here. And it really opened a great world, frankly. Exactly the people we want to be working with at the Media Lab in our burgeoning legal science clinic, and it's taught us a fair amount too. We're going to host one of the New York Legal Hackers events in the Media Lab in June and make real progress on quite a few issues. It might be an area to maybe explore some of the ideas from y'all in the panel about how to transition and what would be taught in order to transform government, and maybe some issues with predictive discovery or library and information science could be modeled in a more of a rapid, low pressure way where there isn't a project launch or a funder deadline of some sort, but we can literally be informal and try some stuff. These hackathons are fantastic, and for a legal hackathon concept, I thank you.
For me, the great homecoming was the Center for Constitutional Rights called me the other day and said they want to do a legal hackathon. That shows that it's penetrated the advocacy community as well. We have a couple questions. I don't want to take away from you, Daza.
I hereby authorize you to take away from me.
This is a great flow. Anyway.
Thank you. So one of the things that surprised me about your panel is I haven't heard any conversations whatsoever about how you use technology to serve as the client. And what's going on in corporate America today is the social business revolution, and I'm not talking about social responsibility. I'm talking about the use of social technologies for collaboration, communication, and the spread of knowledge. And I'm surprised that throughout the conference there's been no mention whatsoever of that. So I'm wondering from your perspective, what do you think of the ability to use social technologies to provide better customer service to your clients and workflow and transform the way people are working, both lawyers and on the business side?
I think that's a different conference, right? So I think that sounds really interesting, but I don't know, you want to talk about
lawyer as a CTO? That's what I'm seeing.
Well, I think
Lawyer CIO.
Well, all right, we can talk about that if you want to.
Well, you've built some social media sites.
Well, all right. You want to? I'll tell you one thing that was interesting, just by way of anecdote, was that when I left Google and went into the White House around 2009, and then came out 2 years later, and by the end of 2011, I was working at Tumblr here in New York, right? So a very young company, and the way that the tech industry that I had experienced in Silicon Valley was doing work in 2009. And what I entered when I got to Tumblr was really different. I had to completely relearn how I work. Tumblr just worked in a very different way, which is now the way everything that I do works, right? So it's a whole different tool set. So where like in our generation, I guess, email is the thing, right? So email. Like everything that happens is email. And I like email because I'm a pack rat. It's searchable. I have all my archives dumped into Gmail, and I can kind of find anything at all times. It's great. I'm a huge email fan. But literally nobody that I work with anymore uses email for anything other than hyper-formal, communications. It's just nobody cares about such a clunky and, asynchronous form of communication. And so instead, everything happens through this kind of slew of different tools, depending on the company and the culture and how you get things done. But it's everything from Asana for project management to HipChat for in-team, inter-team instant messaging, to my team actually talks to each other sometimes in Twitter. We just sort of talk in public about stuff. anyway, it all gets it's like totally weird and jarring for a little while, but works way better. And I feel like we get like a ton more done more quickly. So for example, what is customer service? Well, it's like a website where you enter FAQs and you answer all of them in public and archive all of your responses, and you tweet back at people whenever they've got a problem. And like that's how you do. Anyway, it's just very different. And so what the nexus with being a lawyer is, I suppose, is that you have to overcome, at least up until you're publicly traded, and subject to Sarbanes-Oxley rules, but you have to overcome a kind of a natural lawyer's instinct to have tight control over all of the channels of communication, so that when discovery comes around, you've got your ability to put your hands around it. Like you said, with a client that just says, like, I'm not going to tell these people what to do. Maybe it makes discovery more costly, but we're just not going to. We work the same way. The short, by the way, like important thing to note is that, like, for those of you that are going to be graduating from law school and going out into the working world, and you might think about doing your own thing, because of the availability of these tools and the application of Moore's Law to cloud computing and all that, it is staggeringly cheap to build the infrastructure for an enterprise these days. I mean, it is amazing to me how quickly we can stand up like a complete and robust set of systems in like an hour or two for like zero money, and get to work. It's amazing, and it's something that you should be excited to take advantage of when you get the chance.
I think. Go ahead. I think I would just say that the reason you don't hear more of it is because for us it's such a given that we're not even surfacing it. So we are people who work in an open and collaborative fashion. All of our work, at least all of my work, relates to how to be open and collaborative. We've been doing legal hackathons before it was called a legal hackathon for 15 years now, trying to do things like hack government agencies and hack corporations and turn them into more open ways of working. Adopting the principles of open innovation is sort of inherent to everything that we do. And it is, I'm glad that you surfaced it as a point, because it is sort of antithetical to the legal mindset and culture. And it is also very antithetical, I even find, with my students, for whom doing things like taking shared notes on a hackpad as a collaborative single set of notes, tweeting throughout the class, doing that sort of thing is still is even for students today, generationally younger, but the mindset of kind of the closed mindset is still so pervasive and strong that the notion and the argument that has become better known in business than it has in legal and other circles, that open and collaborative as a way of working actually generates more value and advances the ball and furthers innovation. And we have a whole set of rules that just don't sync with that anymore very well, and we're trying to navigate that. But I think you don't hear more of it just because we as a group probably take it so for granted that we tend to forget. Right.
I mean,
and I'm in.
Right. You're teaching highlight. Law school teaches highlight in black. It doesn't teach collaboration.
And I'm on the exact opposite side. So I work in a large law firm. We have more than 1,000 lawyers. Until recently, it was all dark mahogany and leather-bound books. And it's much more challenging for us to change. And I think it's part of. It's baked into the law firm model. It's baked into the succession within a law firm, the apprenticeship model of rising within that organization, and this thing called educated in capacity, the idea that the more expert you are in a certain way of doing something, the more blind you are to ways to improve doing that. And then we exist in this world where we're under increasing pressure on economics. How can we justify our rates? How can we justify our cost? And there's a growing importance for law firms like ours on efficient project management, matter management, legal project management, and there's a burgeoning industry of that. But the traction that the technologies have and the traction that our clients have in insisting that we adapt to these and accept the changing nature of the business is slow, and it's slow because, again, of the nature of the legal business, and I think there'll be certain people who are successful, and certain organizations will be successful, and certain organizations won't be successful. And I think the successful ones will be the ones who, to whatever extent they can, understand that the nature of things is changing, and
So
we have to.
Andrew, and then Michael.
It's striking that it's striking that none of we work with outside counsel, on things. At BetaWorks we do a fair number of private-to-private deals that need kind of like bespoke, legal documentation, and it's amazing like how weird it is to interact with them. Like they just are on, it's like it's like
It's a throwback.
Yeah, in time warp,
Yes.
I just have to say, just anecdotally, like one of the things that's so jarring for a lawyer in kind of like a startup environment, where, as Beth said, like the walls are fully permeable and communications are flowing in and out in real time, is like the other day somebody on my team was like, "Hey, you got to check this out. It's this really funny, not safe for work thing I just found," and I was like, "You're at work. You realize you're at work, right?" They're like, "Yeah, but check it out. It's funny." It's like. You're like, okay, I guess like the boundaries between home life and work and everybody like with their laptops out, doing, tweeting on the company account at 1 a.m. But it's just like it's completely incompatible with like a nice foursquare, linear, lawyerly, structuring of how a workplace is supposed to function for purposes of minimizing risk, if you view it that way. And instead, you're trying to kind of like maximize risk in order to push your company to take the biggest chances they can take, and smart chances, but to take like big chances, and it's just a completely different.
Michael, you actually know something that's critical here, and we talked about it before. You know a number of things, I'm sure, but like so very provocative concept here about, you could with puppet scripts and some other things, spin up an entire enterprise quickly. I think you said in an hour. I don't know, I could do it in a day, maybe. Between the different systems that you'd need. And then if you look at like the folks from the state of Kansas that had participated in your one of your initial GovLab conferences, Beth, at the Secretary of State's office, they're really seriously taking on the proposition of fully automating corporate filing. Create a new corporation, amend the name, play it out, dissolve the corporation, all online, all digitally. I'm starting to see the contours of an interesting, the shape of things to come, when all the enterprise is truly a digital enterprise and we all are truly knowledge workers. Because of your library science and legal academy background, what you told me before, you said you have a sense of how to structure the data so it shows up as knowledge that is ingestible by business people, by technical people, and by legal people. How on earth do you do that so that we could even seed the enterprise systems that would be fresh and configured maybe on day one, but have no data in them? How do you express data for a truly digital enterprise that can live and die at the speed of light? How do you just express that data?
Right, and I'm not sure I have a complete answer to that. Part of what we talked about yesterday, or is in preparation for the panel, was this notion, of course, that the law is information intensive. I mean, that's the thing I've always thought about. And so that information intensity leads to a couple of different things, which is versus creating a different way to think about what are you seeing in front of you when you look at information. The second thing, frankly, though, is to be able to work collaboratively together. And so one of the things we've done at UMKC is we've installed the Tidebreak software, which is a collaborative software. So we actually have a large tech room where we've got 6 monitors on each side of the room, and then a big screen at the front. And what the software allows us to do is at the table, have 4 to 5 students wirelessly connect to a workspace and then work together collaboratively in it. And then begin to design knowledge objects, really, working together. And so then the instructor can bring them up to the front. So part of it is just this notion that you've got a different way to understand the information that's being presented and how to track it through. I mean, at the end of the day, it's about project management, it's about knowledge management, and that's the kind of thing a technology person, I think, brings to the table in terms of looking at information.
That was cool. Okay, we need that software immediately for the next panel so we can design knowledge objects, because I want to be on that team. We have, I think, one more question from our erstwhile videographer of the internet, Jonathan.
Jolly, my name is.
Oh, Jolly, I'm sorry.
Yes.
Excuse me, Jolly.
So I heard you say at least a dozen times the word agile. I heard you say sprint about 3 or 4 times. I didn't hear you say scrum.
I was thinking it.
Or pigs and chickens. But I wonder how many of the law students here or lawyers know that you're talking about a defined software process. And I'm just wondering how much things like these, the established knowledge and experience of developing Agile as a software process should perhaps be taught to law students and brought to legal law development?
Again, I think you're touching on a burgeoning industry, especially that's touching law firms like mine. Again, we're getting increasing pressure from our clients to lower our costs, and a necessary predicate for that is improved matter management. It touches on knowledge management. How can we leverage past experience for future experience? How can we not rewrite a brief? How can we not redraft the same contract? All of those things are tied to improving the efficiency of the services that we offer. Part of it is technology facilitated. I don't think it will be technology driven. It's not the nature of the practice. But the most, I think, significant stumbling block for us, and perhaps it's greater than a stumbling block, is just the nature of the people who choose, one, to practice law, two, choose to go to law firms like mine, and then three, are successful in these large law firms working on these large matters. Again, the nature of the pyramid of associateship to partnership, it's a pyramid, and there are people who opt in and there are people who opt out. Some of them are opted out. They don't choose to opt out, but they're opted out. But you figure X number start all together, and then X minus a significant number end up as a partner. And the success, the factors for success are tied into this apprenticeship model. They're following their predecessors, and that's why they're successful. So the opportunity to change is much more challenging. And then if you think before 2008, when the economy the economy had all these issues, the GCs were all former law firm people. So there wasn't the drive from the GCs to be more efficient because they came from where we were.
So good. We need to be wrapping now, but it's very good. That was basic context to the question on the proficiency and understanding of this agile method and how it plays in the broader context and the bigger trends. And so why don't we continue wrapping this direction? And Beth and Andrew, last words, if any?
I would just
final thoughts.
So just the final thought is, what's going through my head is, so the way that I teach and work with my students now is very much adopts the agile and design methodologies. And one of the things that they often talk about is how different it is, and I'm sure Jonathan feels the same way, from the rest of their education, because it starts, it goes back to the beginning. We try again. We're very agile in the way that we approach things. That is completely different from a law school class in which you sit from beginning to end, you take one exam at the end, and then you get some feedback in the form of a grade. The essence of that method that we begin in the first semester of law school runs counter to everything that designers and hackers and technologists use in the way that they work and the way that they solve problems. So I think until we kind of until we change that core building block of that, and which is tied into a whole set of other economic processes, etc., I'm going to sit here passively and receive some content. At the end, I'm going to take an exam in which I parrot something back. Until more of legal education, until sort of Jonathan's class doesn't become the required first-year curriculum instead of the capstone of the third year, because that is what real life looks like. It's about starting and stopping and doing over and fixing again and hacking and redoing and fixing it on shorter deadlines. Which is why, as you were talking about architecture before, I was thinking what a lawyer hears by that is I have to architect every possible permutation till the end of time before we do something, whereas you mean something very different. I think we mean something very different, which is we're going to do things in an agile way. We're going to do things quickly. We're going to see what works. We're going to learn from it. We're going to try to do things again. Till we adopt that experimental mindset in our institutions and in the academy, we have a lot of work to do. We'll be having this panel again next year.
Yeah, Beth, from your lips to our dean's ear. Do you have a little more?
Do you want? You don't want to teach the whole first year class.
Would you like to say anything else? No. So, if I may, and just by way of a closing wrap, say, we had a chance to have a sidebar, and Jonathan and I, a few moments ago, and agreed that at some unspecified date, which we haven't set yet, but now we'll set in coordination for the program here and with Jonathan, we will have our next legal hackathon at MIT using your system, NY Legal Hackers. And one of the panels, which I'd been thinking about doing before, but I just decided we're definitely going, not a panel, I'm sorry, one of the projects, an agile project of the type Beth just implored us to adopt, basically, in legal education and law practice, is I call it CorpBot, or basically it was CorpBot dot everything, and it'll be basically let's stand up an enterprise from nothing and design its systems, and there's legal aspect, business aspect, technical aspect,
Who gets the credit?
and then maybe we concoct it in a way so that it's dealing with government in some way. So Andrew has kindly agreed to talk later about some of his concepts about how to do that, but I'd be interested to learn more about how you would spin up, literally, a corporation in an hour or two, and maybe we might adopt some of those methods. Maybe some of you have ideas, but the challenge is we now have a forum. We have agreed between the Media Lab and your institution, in the form of your agents, me and Jonathan, to have a forum. It's the next legal hackathon, and I challenge you here in the room and you out there in cyberspace, you, to come and participate. And you can do it online and on Hangout and literally invent the future. Now, I don't even think we're at reinventing it now. And why don't we attempt to apply and figure out how to apply these agile methods to the practice of law and result in a corporation and maybe let it live for a little while. Who knows, maybe we can dissolve it by the end of after a good life at the end of the weekend. But anyway, that is the challenge. We have a few other projects going as well, which we can think through. But so it has been born, and let us play these ideas out and use it as the parameters of some of the things we'll test, because they were great ideas from every one of our panelists. You guys really fulfilled, I think, a tall order that Jonathan put before us with the title and with the theme of the conference. And I have to say it was not just an honor, but it was a lot of fun, and really I learned a lot and took a lot of notes from being able to help facilitate your dialogue. And thanks for the opportunity. And why don't we all thank them right now. And back to you.
So I offered the convocation. Now I'm supposed to do the benediction. And a fitting place that you had a sidebar. So speaking of bars, I think that Jonathan and Paul should find an establishment that's appropriate and invite those of you, including our many students. I'm glad to see Jedediah and Jared, our winner yesterday of the Shark Tank competition, Francis, so many others of you here, and find an appropriate place to have a round or two on me. Send me the bill, I'll take care of it. And I think that would be an appropriate way to celebrate and further stimulate the fertility of this conversation and keep it going. I would have been with you more had I not been so busy today chopping law school prices. My arm is really sore. Some of you may have noticed. Now, it's not just that I like to say that we're way out front, and online you may have seen the New York Times has a marvelous article, James Stewart, I suggest you look it up about that. Now, the reason that this ties into what we're talking about here is, first of all, at this law school we're taking a very modern, entrepreneurial, if you will, approach to things. I don't believe the business model of law school makes much sense. Law schools around the country feel pressured to do less and charge more. To me, that just basically is wrong. So what we're doing, we're taking a different approach. We're doing more and charging less. And I think that actually will be an irresistible model. But we'll see. Who knows? Sometimes when everybody else is not doing something, there's a reason. But we're going to see it. Now, the reason this directly relates is the true motivation for this is that it's an access to justice issue. It's an access to affordable education issue. And there's so many people who have an absolute desire to attend law school, and including this law school, and for this very special offerings, including a CUBE, but they can't afford to do so, and so their ability, their motivation is there. And we're not talking about below the poverty line people. We're talking about people from all different kinds of background. They're just afraid to take on the high cost. And then if they do come to law school, they graduate with such debt that this is where it really fits, is that they are not able to pursue jobs and careers and opportunities that fit their passion, their talent, their preparation. They feel constrained to search for jobs, sometimes unsuccessfully, that can pay off the enormous excruciating debt load. So we want people to be free if public service is what they want to do, but the jobs may not be as high pay, or if the financial arrangements are such that you're not getting a steady paycheck at the beginning. In other words, working in an entrepreneurial operation, the type of work that many of the CUBE clients are engaged in. We want people to be free to do those kinds of activities. And so, in fact, the business model and the tuition cut that we've announced today as part of an overall package we have to start to make law school more affordable. By the way, Brooklyn Law School is not going to be inexpensive after this, but it's a beginning, and I hope that others will follow, and we're working on it, and it does relate. For me, this is a particularly gratifying moment. It's sort of a bookend or a bracket. Today's Brooklyn Eagle is talking about, Monday's Brooklyn Eagle will be talking about law and cyberspace in today's program, which is quite remarkable considering that, you know, in the 1850s, Walt Whitman, as the editor of the Brooklyn Eagle, was talking about slavery and how wrong that was and the need to address that problem. And so now we're talking about law and cyberspace and the future and opportunity and all of that. But today's Brooklyn Eagle article is about our tuition reduction. It has a picture of me in it with my hair standing straight up on end, looking like the actor in Back to the Future, the mad scientist. I sleep in a tie, so it's one of the few pictures with an open-throated shirt, and so on. And that picture is from 2 years ago this week, your hackathon, which was the first Brooklyn Law School event I attended. I wasn't even the dean yet, but it sounded like a good idea to me, so I showed up and gave a talk. And so this is a perfect, full circle. So trying to make sense of today's program, not that it has to make sense, but what is sort of the coherence and big takeaway? And when you look at the program, and if you participate and get snippets of all these different panels, it's a little bit like trying to take a sip at a fire hydrant. But that's okay, because enough will hit in the right place to kind of make a difference and stimulate. We're not trying in any of these programs to give away the store. It's a beginning, it's not an end, and I think it's been very, very productive. But after all, there are 6 sides to CUBES. There were 6 different panels, very different topics, although there were 2 related to raising money. And then, you throw the cube and it spins, and we had our, speed talks, which is kind of amazing to see that. And then right smack in the middle of the day at lunch, and I caught some of this, there was sort of this manifesto talk. It might amuse you to know that I had just gotten off a 2.5-hour conference call with the ABA discussing the upcoming 2015 tour in the United States of the Magna Carta. And so, the entire lunch theme was tracing, the origins of what rules do we establish, through whether they're laws or code in terms of legal order when there's a vacuum, but tracing it all the way back to Magna Carta. So it was kind of apt that I would come from that clunky ABA discussion and hear folks talking in terms of cyber manifestos and so on. So it was really quite a remarkable relevancy for me for this discussion. This panel is extraordinary. In particular, I've looked up to many of the people who are here. I heard Beth, both in her comments and in the very last comment that she made, really make comments that distilled what CUBE is all about. And that is when she said, and I'm paraphrasing, that about lawyers being in at the beginning and not just later on. In other words, what CUBE is about is preparing young lawyers to be in at the takeoff, not just the crash. And when you look at new ventures and new enterprises, so many of them fail for kind of classic reasons, but one of the reasons is that they're not infused with legal DNA at the start. And that really helps. But they don't, understandably, because first of all, their vision and the lawyers that they have known speak in a different way. And what CUBE is about is giving people experience working with entrepreneurs, working on new projects, working on new ideas and new ventures within a large or small organization, and working with this evolving new culture that has been described in this panel today. And learning how to say more than no, you learn how to say here's how, or why not, or did you think about this, and that kind of approach to law. And so I think it's incredibly important. I think this is a very successful and appropriate beginning of CUBE. As our first symposium, it is a wonderful start to something that only began this year. People ask me what CUBE will look like next year and the years after. I can tell you truthfully, I have no idea, and I don't even want to know. It's going, and I say this to people, and traditional academics get a little uncomfortable. Lawyers get uncomfortable. My board looks on me when I say this the way that I think the Reagans looked on Ron Reagan's ballet career. You know, they're officially proud, but privately they're a little nervous and don't know what to make of it. But when I say the following, we are building the plane while we're flying it. CUBE is not a 20th, 19th, 18th, 17th, 16th, 15th, or medieval model of an academic enterprise. CUBE is a 21st century academic enterprise. Our funding for it was not, the approach was not to go out and raise $25 million and then live off the endowment and plot ahead. Our donors who are successful, our founding donors who are successful entrepreneurs themselves, damn it, want to hold our feet to the fire. So they only gave us enough funding to last for 18 months. And then to see what we really need, what we're doing, and to evaluate how we were using their money. Every one of our founding donors had the capacity just to kind of give us a big bundle of money and to move forward. So they've actually put us to the test. So I hope that in these concluding remarks that they're not only appropriate, but they kind of somehow give you a feel for what we're about here at Brooklyn. We are making a lot of changes. We're moving ahead. We're having some fun while we're doing it. We're doing things consistently first for a bunch of reasons. I heard a lot about agile. We're nimble here because we're an independent law school and because, as you know, a lot of us don't necessarily come completely from the traditional academic background. We don't know any better. So we're just trying to move ahead. And also in Brooklyn, we're a little impatient, you know, in terms of waiting. So that's why we're a little restless. We're not afraid to have something worked out. We have the confidence to know we can learn from things that don't work and move forward. And so in that way, the whole vibe here at Brooklyn Law School is very much consistent with what CUBE stands for and what all the people who participate in this conference stand for. Thank you very much for coming, and I hope that Jonathan takes you to an appropriate pub or bar, or if you're really shortchanged, you know the back room in my office will take care of almost everybody in this room. Okay, take care.